signature, your lordship. Praying for kind leave, my lord, for filing mandamus appeal without certified copy of order. We have applied for the same on 6th of August, my lord.
Leave granted.
My lord, paying for a leave to file an appeal without a certified copy of order.
Date of the order.
My lord, 28th July. My lord, it was uploaded. My lord, we had already applied for the certified copy, my lord.
25 means it will be out of time. We'll ask them to issue the certificate copy.
My lord, we have already applied for it.
We'll ask them to issue the certificate copy today so that you will save on limitation. Otherwise, it's out of time.
That already I'm filing the section 5 limitation because there is.
With section 5. Okay. With section 5. Yes, sir.
Under very peculiar and forced circumstances, I'm mentioning this matter. My lord, there are two writ petitions. Point of time, this was the second one. The first one was heard by the Honorable Mr. Justice Biswajit Basu. But at the time of delivery of judgment, since the learned Advocate General took an exception, His Lordship was pleased to release the matter. Now, Your Lordship was pleased to assign that writ petition in before the Honorable Justice Bivas Patnaik. That is fixed for hearing today at 2 p.m. Now, what happened that on illegal governing body, according to us, there is no reconstitution. That illegal governing body has now suspended again when the point is pending. But they have suspended the principle. Now we have to question this is a fresh cause of action. Now I mean original determination of Justice Basu. Justice Basu is not available right now. So determination has been given to Justice Bhattacharya. I mentioned it, but Justice Bhattacharya's view, since the other matter has been assigned by the Chief Justice, Justice Patnaik, how can I take up this matter? According to me also.
You give a letter today.
Both the petitions should be heard by one honorable judge.
All right, but 2
2
p.m. you want this also
this
to
is
be.
also to be. That's the because kind of consequential acts, Your Lordships. I'm conscious of doctrine of consequential.
Have you filed the writ petition?
Yes, yes.
Numbered.
File we have not yet. I'm sorry, madam. I'm also asking for leave.
No, leave can be granted.
Your Lordship, but Justice Bhattacharya refused to grant me leave. This is assigned.
Then
What
how
am I
do-
to do, my lord?
How this bench
Your
can
Lordship, being a Chief Justice, can do that.
I should do it on the administrative side.
That's Your Lordship.
That you make a request in writing. Let
All
the
right,
council on
both
record
I later and I'm giving to Your
and
Lordship.
give it to the OSD.
Much.
A listing of these two matters, my lord. Small matters.
Difficult, sir, difficult.
Small
You have
matters.
to pass one more.
My lord, I
today
am
we are
humbly
going to-
praying, my lord, item number 49 of your original site monthly list, my lord. This is a wagon matter, your lordship may remember.
You give, let us see you next week if possible.
Next
Yes,
week,
sir.
this week cannot be, my lord, because
My lord, we have my lord's kindly, my lord, the judgment delivered by your lordship in the Indian oil matter, my lord, there are 3 or 4, my lord, we find some typographical errors.
Pardon?
Typographical errors, 3 or 4 typographical errors are there. But typographical
errors.
but I've indicated in pencil, my lord, at page 3, page 5 and page 21.
Page 3, page 5.
My lord, page 3, my lord, this third line from the bottom, my lord, is
Page
2022, my lord.
And
my lord, page 5, my lord,
5, yes. 8
Lord,
weeks.
page 5, my lord, that will be 8 weeks, my lord. And my lord, page 21, my lord. But one is, my lord, the first paragraphs, my lord, third line from the bottom, first paragraph, my lord. Extra 10, it should be enter 10, my lord. And my lord, then, my lord, some paragraph,
days list.
Panchanama date is 2020, my lord.
My lord, may I have kind leave to mention one matter, batch of matters where delay has been condoned by Milord, and one matter they have opposed, so the delay was not condoned, could not be condoned, and matter was fixed to come on 28th, my lord. May kindly it be listed, my lord. Only this matter.
28th of
August, my lord. Only this matter is pending for delay hearing. My lord, since they have opposed, my lord could not. Only this delay part, my lord. Only this.
I have kindly information with regard to item number 16 and 17 of the appellate side. It's a review matter passed by your lordships only. That what happened that matter, your lordship has dismissed the appeal, affirming the order of the London single judge with regard to payment of admitted amount. But they have only to drag the matter, they have filed the review, but this has not been.
No, it's running in the list today.
Running in the list 16 and 17.
Let us see the second half. Justice Hiranbhai Bhattacharya will be sitting.
My lord, may I leave to mention one item from monthly list of original site?
So wait, sir, wait.
Article list. This list of your lordship's present detail.
Oh, review. All right, you give the number.
16 and 17.
Yes.
My lord, may I leave to mention item number 149 of your lordship's monthly list in the original site? My lord, this matter has been heard substantially on 25th of August by your lordships of Mr. J.K. Mittal, and it was heard substantially, and only a short compilation your lordship was pleased to direct to file and serve. We have done so. My lord, it will take maximum 10 to 15 minutes. My lord,
Serial,
can be accommodate any day subject to your lordship
all right.
convenience.
Serial number 149.
My lord.
Okay. Please make a note.
My lord, this is item number 19.
My lord, when can it be listed, my lord? 149.
You please let us, you give the number, let us see.
My lord, grateful.
My lord, this is item number 19. And my lord, I hope remembers my case. My lord, time is running out for me. I have only less than 2
Which
weeks.
19 in which list?
Kindly keep it in
This
to be
list.
mentioned, my lord.
Let us see.
So, my lord, can it be kept in to be mentioned? Just it has been disposed of as to be mentioned, my lord.
All right. You
So-
take the number and put it little higher tomorrow. Please call.
What is your daily statement number 1? I am for the appellant. There's a delay of 251 days.
Hmm.
But
Two?
251 days. But this is not an arguable case. Kindly delay, condone the delay and because there has been 263 has been done twice.
Second time.
Second.
And lordship, lack of enquiry is also written by this.
All right. This appeal has been filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act, challenging the order dated 8/12/2023 passed by the Income Tax Appellate Tribunal, A Bench, Kolkata within bracket Tribunal in ITA number 318/KOL/2021 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. Where are the questions? Yes. Page number 8. Para 6, 1, 2. 1, 2 not required. 3 not required. 4. 5. We have heard so and so. There is a delay of 251 days in filing the appeal. As the explanation offered by the appellant department is satisfactory, the delay in filing the appeal is condoned. GA 1 of 2024 is allowed. Para. The revenue is aggrieved by the order passed by the learned tribunal dated 8/12/2023, by which the appeal filed by the assessee was allowed, and the order passed by the Principal Commissioner of Income Tax Kolkata 4 within bracket PCIT under section 263 of the Act dated 12/3/2019 was set aside. We have carefully examined the order passed by the learned tribunal and noted the submissions made on either side. It is not in dispute that the present that the power under section 263 was invoked by the PCIT for the second time. And in the first round, the PCIT, by order dated 9/9/2016, set aside the assessment made under section 143 within bracket 3 dated 16/3/2015 and assessed the income at rupees 6,21,01,240. The assessing officer passed the fresh assessment order under section 143 within bracket 3 read with section 263 of the Act dated 21/10/2016, making an addition already made under section 68 of the Act in respect of the share capital / share premium was deleted and income was assessed at rupees 1,240. The assessing officer called for the necessary details from the assessee and also from the shareholders under section 133 within bracket 6 of the Act, which were duly complied with, and by a detailed order, assessment order, dated 21/10/2016, the addition, the deletion of the addition was made. The PCIT was of the opinion that the assessment order dated 21/10/2016 is erroneous and prejudicial to the interest of revenue, and alleged that the assessing officer has passed the order without carrying out detailed investigation / verification / independent inquiry regarding identity, creditworthiness of the shareholders, and also genuineness of the share transaction relating to share capital / share premium. Accordingly, notice under section 263 was issued. However, it appears that the assessee did not submit a reply. Finally, the assessment order was set aside, and the assessing officer was directed to frame the assessment de novo in accordance with the provisions of the Act. The issue which fell for consideration before the learned tribunal was whether the power under section 263 was exercisable by the PCIT to set aside the assessment framed under section 143 within bracket 3 read with section 263 of the Act on the same issue on the ground of lack of inquiry into share capital / share premium. The learned tribunal, after carefully examining the facts, opined that it is not a case of no inquiry or lack of inquiry, as the assessing officer has made inquiry and taken a view on the basis of after considering the evidence furnished by the assessee as well as by the share subscribers. Furthermore, the tribunal on facts found that the twin conditions which are required to be satisfied to invoke the power under section 263 were not complied with. Accordingly, the learned tribunal, after taking note of the decision of the Honorable Supreme Court in Malabar Industrial Company Limited versus CIT 2,243 ITR 83 within bracket SC, held that if only one of the two twin conditions are satisfied, the provisions under section 263 of the Act cannot be invoked. The court also took into consideration the decision of this court in PCIT versus Bhagavati Wind Trade Private Limited, ITAT 184 of 2022, and PCIT versus Messrs. M.S. Intent INTENT Dealers Private Limited, ITAT 92 of 2022, and allowed the assessee's appeal. Thus, the learned tribunal, on examination of the factual position and also noting the legal position, has granted relief to the assessee. We are satisfied to state that no question of law, much less substantial question of law, arises for consideration in this appeal. Accordingly, appeal fails dismissal. Next.
Number 2.
We are for the petition, Your Lordship. As per your Lordship's direction, we have served copies upon the respondent. As well.
The respondent has been served.
Yes, Your Lordship.
Any affidavit is being filed?
My Lord,
Any affidavit?
so far, my Lord, I appear for my Lord, contempt number 1. That is, my Lord, the Principal Secretary of the Transport Department. Now, my Lord, the main order was, that was, my Lord, 24th of, 8th May, and my Lord, that is 8th May 2023, and my Lord.
But actually, what is the intention, sir? Let us make
My
this is a, I think it's a wasted effort. We passed an order, constituted a committee. She was made part of the committee. Then the Advocate General appeared, etc. Gave an impression that you are very proactive. You want to run the tram at least in a couple of routes. You say something in court, but what is being done is something exactly opposite, diametrically opposite. So probably it's an attempt to hoodwink the court.
That is not correct.
You take an order on merits. You could have taken an order on merits. No, I will scrap. I will dump all the tram. I will throw out all the employees. I will not pay them anywhere. Let them all die. You make a statement on affidavit.
I think, Malad, that is
This
not.
is the only city where this heritage is being
True.
Still operational.
At least
But
in two or
then
three.
you can demolish these buildings, sir.
May I tell you?
If you demolish this, you can construct 20 floors. Please do it. You can demolish writers' building.
Heritage, that should be as well.
You are not concerned about heritage. Though you have a heritage committee, PWD has got a heritage wing. Nothing, no concern.
I think at one point of time, my lord, since my lord, the Calcutta, my lord, the proper Calcutta cannot be extended any further. At the same time, my lord, the population and the volume of the traffics, including my lord, the vehicular traffics, my lord, which is my lord, there should be a balance. And my lord, the tram line, which is obstructing with regard to the flow of traffic.
All right.
That is why, may I tell?
What happened to the SLP file?
SLP, my lord, as it appears, that is why I want to draw your lordship's kind attention. It is still pending, and it appears from my lord, the order of the Supreme Court, which has been annexed here to 49 na koto dekalam tomake?
Then we will wait for the outcomes.
Page number 48.
Otherwise, what happens is, as if they are being coerced to comply with, etc. As a council, you can argue, but as a court, discipline demands us to await the superior court's verdict on the issue.
Next date, lordship, 25th
Any
November.
order passed, assuming it is dismissed, that will also have an impact. Your hands will be strengthened. Suppose there is a small variation, or the appeal is allowed in whole. So therefore, it is better that we wait.
25th of November, as it appears from page number 48 itself.
So, since the state has preferred an appeal before the Honorable Supreme Court against the order dated 14/1/2025 in CPAN 1406 of 2024, in WPO P12 of 2022, and in the said specially petition, the Honorable Supreme Court issued notice to the respondents who are the applicants herein, and the matter has been listed on 25th November 2025. Therefore, judicial discipline demands us to defer the hearing of this proceeding beyond the date fixed by the Honorable Supreme Court to hear the specially petition. Accordingly, let the matter go out of the list. Liberty is granted to the learned advocates on either side to mention the matter after the disposal of the specially petition. Yes.
Number 3.
Only a short clarification.
My lord. Lordship, that is in item number 4, Lordship.
Oh, 3.
My lord, item number 3, my lord, last day had passed an order that they had, the SESTAT had rejected the demand for the period of 2011 to 2013 on the point of lack of jurisdiction. However, my lord had indicated in the order that for the previous period, the adjudicating authority had accepted their claims of Senvat credit for 25 crores. So they could not take advantage of the lack of jurisdiction point for the same order for the rest of the period for which a demand was imposed.
And we directed you to file a compilation. We'll take that today. Then let it come. The next matter you completed. In terms of the directions issued in the order dated 25th July 2025, the learned advocate for the respondent has filed a compilation, which is taken on record. Copy of the compilation has been handed over to the learned advocate for the appellant today. Let the matter appear after 3 weeks.
Great.
Only a couple of clarification. Please tell us where is the order passed by the Assistant Commissioner rejecting your application for refund. Page number.
First order, Lordship.
Order.
First order, Lordship. Lordship will take the stay application. Volume number 1, Lordship. Page number 34.
Page 34.
Lordship.
It starts at page 34. This is the interest order of Assistant Commissioner, no?
Yes.
This is Lordship.
Deputy Commissioner.
Deputy Commissioner. Where the rectification was rejected, Lordship.
Well, not the interest. This is the original order. This is not the interest subject.
Order?
Lordship is talking about the interest component of the first order. First order is here. Which is the operative portion of that? It is one page order. It is the single page. Oh, only one page. There is no mistake. On verification of the related documents, it is seen that the shipping bills in question were assessed based on the declaration of the exporter with regard to the description of good, percentage of the FE content, quantity, etc., and the related documents submitted at the time of assessment, including invoice, pre-shipment, so and so. It is seen that there was no mistake, clerical or arithmetical, on the part of the assessing officer in the assessment of the said shipping bills. Therefore, it is not a case covered under section 150. All right. Now, after challenging this, you filed an appeal to the Commissioner.
Lordship, Commissioner appeal.
Where is that?
That order is in the next page, Lordship. Page 35.
35, 31, operative first, page 30.
And Lordship,
Operative.
the observation starts from next page, page 5, Lordship.
This is
Page 5.
dated 11th October 20.
11th October 2010. And Lordship may kindly take paragraph 5.
11th.
Page 37.
Date of order, no, 6th October. Issue
6th October.
Date of order.
Date of the order, my lord, 6th October. The issuance order is 11th October. My lord,
6th October.
my lord, my list of dates will be helpful with you. Yes, ma'am. Sorry. We have gone through a list of dates. Clarity is there. Only for Lordship. Just answer 4-5 questions. Yes, ma'am. Then you both of you will be relieved. Para 5.
Para 5, Lordship. Page 37.
Where he holds that this assessment is contrary to Gangadhar. Assessment should be done by the first determining the FE content and above base ratio of the Supreme Court. And ultimately, what is the direction? Remand. Well, it is from page 38, bottom. After setting aside the decision under the impugned letter dated so and so, I order that the lower authority shall dispose of the representation of the appellant under various letters and to determine whether the case of the appellant fits in under the errors arising out of omissions. In doing so, the lower authority should consider the ratio of the judgment referred to above and the meanings given in to the term omission in various dictionaries, and thereafter pass order, give the decision, and after providing opportunity to the appellant. The appeal is allowed. And against this, my lord, it was remanded back, and the original authority again passed the order. That is on page 41. Order, second order was passed.
Second order, Lordship.
Was passed, affirming the adjudication order.
Which is in page 41.
Yes, ma'am. Sorry. Yes. Page 41.
Lordship, the very next page, Lordship.
Sorry.
Dated 11th of May 2015, Lordship. After 4.5 years.
After 4.5 years.
Lordship.
Correct. You did not file a writ petition or anything to expedite?
I filed, Lordship. The writ petition against the Commissioner Appeals Order, Lordship. No, Lordship, against.
There is subsequent.
No, Lordship. Kindly allow me, Lordship. I will just clarify, Lordship. Against this order, 11th of May 2015, Lordship, Commissioner Appeal, Lordship, merely one-liner order, he dismissed my appeal. Which starts, Lordship, in page 48.
64.
13th of May 2016, Lordship. And only observation in only one line, Lordship, in the last page, page 64.
Page 47.
Page 48, Lordship. This order in appeal starts from page 48.
No, we are in order in original.
Lordship.
Page, why are you jumping?
Well, order in original 41, subject to correction. 41 is the second.
Lordship. Second order where the remand proceedings, Lordship.
I hereby reject the request of rectification.
Lordship.
So, rectification rejected. Then what happened?
I filed appeal, Lordship, before Commissioner appeal. And the order is in next page, Lordship.
Page. Sorry.
48. And where is the operative portion?
Lordship may take page 63 straight away, Lordship. Page 63, Lordship, at the bottom. He mentions that the authorized signatory appeared and filed submissions. Then, Lordship, the next page.
Yes.
Lordship, in the next page, appeared so-and-so on behalf of the department and pleaded that the subject case does not warrant rectification under section 154 of the Act. Order. I have gone through the grounds of appeal submission made during the course of personal hearing and all other evidences on record. The delay in filing appeal is condoned. I find that the lower authority has passed the impugned order supported with cogent reason as mentioned above. I find that the Honorable High Court of Calcutta in its order dated 10th of September 2015 has made the same observation. This, Lordship, I am sorry, Lordship.
Now, please show that writ petition order.
Lordship, that order has not been enclosed here, Lordship, because that was my writ petition was dismissed on the ground of alternate remedy.
No, what did you challenge or what is the prayer?
Order in original, Lordship.
Oh, challenging O&O.
Lordship.
Dated 11/5/2015, writ petition was filed,
Lordship,
which was dismissed on the ground of
alternate remedy, Lordship.
Thereafter, you filed appeal to the Commissioner.
Yes, Lordship. After the High Court order, I came in appeal.
All right. Now, where is the appellate order?
Then, Lordship, the tribunal's order.
Against the Commissioner's order, you went before the tribunal.
Commissioner appeal, then tribunal.
That order is at page 66.
66, Lordship.
28/7/22.
Lordship.
After 6-7 years.
And the finding is at page
68
onwards, no?
Yes. Para 5.
But one mistake the tribunal committed was they thought there were test reports were there. There are no test reports. So representative samples was not drawn.
No.
At the first instance.
No.
You see at page 69, para 8, it gives a specific direction. It is also directed that relief as per notification so and so be given, taking into account the test report. So we have to omit that. So the tribunal set aside the order and remanded the matter, directing benefit of notification.
Lordship.
Correct. So allowed.
Finalizing assessment.
Sir, finalizing speaking order.
The impugned order is set aside with the appeal is allowed by way of remand to the original authority with a direction to pass a speaking order finalizing the assessments. It is also directed that relief as per notification number be taken into
So
account.
it doesn't stop with speaking order.
No.
It says give benefit of notification.
Yes. এবার আমরা কবে sanction করলাম? আমরা
appeal করলাম।
Lordship, I have to make small submission, Lordship. No, Lordship, this test report, Lordship, the order in 2023 has duly noted, whereby my refund has been granted. It has been duly noted that the test reports were from day one, it was already submitted in 2009. So test reports were well before the authorities in 2009 itself, Lordship.
No, representative sample was not drawn.
Lordship, Lordship, the question of drawing sample was not required because, Lordship, when I
Then
filed.
what will they test?
Lordship, this test report is not relevant, Lordship, because, Lordship.
That is what we said. It's a superfluous.
Lordship, Lordship.
Admittedly, there is no test report.
Lordship.
Then what happened?
Then, Lordship, the Honorable High Court, Lordship.
Now they sent it back. Tribunal sent it back.
Lordship.
Now the authority, what did it do?
Went to cast appeal, went to
Page number 100, Lordship. Before this coordinate division bench, Lordship. And before that, they rejected my refund.
That is what, don't jump, sir.
Lordship, that rejection, I am sorry, Lordship.
So, once again, page 92.
Lordship.
92 to 5th January.
Relevant paragraph will be
page 98.
95 থেকে চলছে
Paragraph 18, Lordship.
95 থেকে finding.
95 is the discussion and finding, and the
Page
penalty
98 is the order.
So they rejected the refund application.
Again, on the same ground, Lordship, that
you have said in your written notes.
Yes.
Same
Lordship, that I should have challenged by filing an appeal.
Then you filed a
writ application.
No, Lordship.
So we filed a cast.
I filed, Lordship, writ petition before single bench, Lordship. But in the meantime, the revenue already preferred statutory appeal against the tribunal's order 2022 order, which order is in page 100.
This was dismissed.
Lordship.
And with certain observations, directions.
Lordship, the observation starts from page 102.
102 and 104.
104 and 5.
Lordship.
Yes. Then they granted the refund.
No, Lordship. Lordship, then
single bench order.
Then, Lordship, my writ petition came up before the Honorable Single Bench.
Yes.
Which is in page 106.
They are taking note of the division bench order.
And the tribunal's
order. Tribunal's order.
Lordship.
Commissioner's order.
Lordship.
Page 109.
Yes, my lord.
Before that, Lordship, page 108. In the middle, Lordship, considering the aforesaid factual and legal position as appears from the record, now the question arises as to whether the adjudicating authority, in passing the impugned order in original dated 5th of January 2023 on remand, has acted strictly as per the observation, findings, and direction.
Not acted.
Has not acted.
You missed not.
Has not acted strictly.
I find that the adjudicating authority has not acted strictly as per the findings of the directions given by the letter. Rather, it has given its own reasons of opinion.
Lordship, I am reading just 2 lines above this, Lordship.
Has acted, all right.
Lordship, then Lordship is reading correct, Lordship. I find that they have not acted thereafter, Lordship.
ভালো নিয়েছো, small scale.
Pencil দিয়ে।
Therefore, O and O dated 5th January set aside.
Lordship. To implement the aforesaid order of the tribunal dated July 2022.
Remand that to implement the aforesaid tribunal and strictly the person in.
Yes.
Then Lordship,
thereafter the reassessment.
they have Lordship in this order, Lordship, 5th of September, they admit that entire material was there way in 2009 and they have sanctioned me the refund.
Well, it has been reassessed. There is no readmission. My submission. 124 is the penultimate order.
No, Lordship.
And against this order, no appeal. I mean,
No, Lordship.
of course, it is attained.
No, Lordship. What has happened, Lordship? Thereafter, Lordship, they granted me refund by or this order in September 2023. Since they did not consider the interest, question of interest, I again filed an appeal before Commissioner Appeal, which is, Lordship, in second volume of the stay application.
প্রথমে আমাদের রিজেক্ট করে দিলাম ইন্টারেস্ট
No,
পেজ
no.
141 টা
Page
রিজেক্ট
141 is the rejection. They applied for rejection, applied for interest, which was rejected on 27-28 November 2023. Page 141 of the second volume.
সেকেন্ড ভলিউমটা আছে
Second volume.
Lordship. Page 141, Lordship.
Page
141
141 of the
Lordship.
second volume. Briefটা দাও।
Where I claim 12% interest, Lordship.
ঠিক আছে 141 টা পাঠ করুন।
ফাইন্ডিং পেজ 1
Finding is in page 145.
Right.
কমিশনার রেগুলেটর 146
Right.
Oh, you made a separate claim for interest.
Yes.
That was rejected.
Lordship.
Volume 2.
Order dated, Lordship, 28th of November 2023. And the finding is in page 145.
No, you said you filed an appeal against the order.
Thereafter, Lordship. I have skipped that. I am so sorry, Lordship. I am so sorry. I am so sorry, Lordship.
You have to be clear on facts then.
Lordship, Lordship. I am so sorry, Lordship.
that's the
Then you preferred an appeal before the commissioner.
Lordship.
146 পেজ নাম্বার
Page 146, Lordship. And the finding is in page 153.
Once again, matter remanded.
ডিমান্ড
Lordship, para 24.
why do we count
Might be
it is not getting start again
He said may be counted from the date of the sestat order.
2022.
22.
Lordship.
দিলে তো মনে হয় তো ট্রাইব্যুনালে 7 বছর মামলা পেন্ডিং এই পিরিয়ডটাতে একটা 6 বছর 8 বছর
Against which you came to the tribunal impugned.
হয়েছে কি করে এটা আমাদের ফেভারে দিকে যে না ওটা ফাইনাল অ্যাসেসমেন্টই ছিল, প্রভিশনাল ছিল না।
Tribunal granted interest from 11th of January 2011.
3 months after the Commissioner Appeals order, first Commissioner Appeals order.
That was on 6th or 11th, 11/10/2010.
Lordship.
Yes. That's all.
Lordship. Lordship, in my written submission, the way Lordship has recorded the chronologically, I have Lordship in my all submissions, Lordship, I have referred
Gone through.
page number.
Gone
And
through.
Lordship, only Lordship only. Kindly allow me, Lordship. Lordship, when I write in 2009 that this order may be rectified under 154, I categorically mentioned, Lordship, that as per the Supreme Court judgment in Gangadhar Das, Lordship, that valuation has to be done in such a manner, Lordship, which is in page number 32 of the first volume of the stay petition, that is dated 1st of October 2009. From day one, Lordship, I have been taking this stand that because this valuation is not correct, not in accordance with the apex court order, so it should be rectified. And Lordship, all along in Lordship, at every stage, they proceeded on the point, Lordship, that I have not challenged the assessment.
That we are clear.
Lordship.
We have heard so and so. Judgment reserved.
Obliged, Lordship.
Appellate side. Who will appear?
Item number 1. Not I am appearing for the minority. Tax effect got 1 crore at.
You got a written instruction? No.
No, my lord.
All right. Sir, low tax effect.
Below left.
Same order, preamble, etc. What is that?
Below tax effect circulars, my lord. Not required. Well, here is a paragraph number 5 of the stay petition.
You can mention the tax effect. Please note down 1, 10, 32, 251.
Yes, my lord.
No, item number 1 in the monthly list. So on the first preamble again, so and so on the ground of low tax effect. This amount is. Thank you.
कागज हमारे
Yes, sir, please call.
Matter item number 1.
What is the correction?
Your lordship, it has 25 or 20.
I think it is 24, your lordship has written. That is,
Oh, the case number has gone.
case number is wrong. One more thing, my lord. Your lordship, my lord, don't take it otherwise that lordship, we have heard Mr. Vinay, my lord, he argued the matter.
He only argued.
His name should be there.
Assisted by Mr. Vinay sir.
Yes, assisted by me, of course, my lord.
He only argued. Why you put you did Agarwal's name you have not put? We have heard Mr. That mistake also you rectify. It has already been uploaded. No?
Item number 2.
But I am for the appellant in this matter. The appeal was served on the respondents and
No, Mr. Kundalia is there in this matter.
How much time it will take?
my lord,
How much time you will take?
I will take 20 minutes maximum.
What is it?
My lord, in this matter,
Just without opening the brief, you tell.
in this matter, I have challenged the adjudication order on the ground that the order was passed in violation of principles of natural justice. In this matter, the writ petition, show cause notice was issued to me, and one hearing notice was given, and I was not present on that day. On the next hearing notice, I was present before the authority, and I requested for 10 days time to file the reply. And within 10 days, I have filed my reply, and the authority passed the order in original without granting me any further opportunity of hearing, and passed the passed the adjudication order.
But why was your writ petition dismissed? On what ground?
On the ground of alternative remedy. My lord, I have prepared a short list of dates.
The problem is,
My lord,
if you had assessee had been vigilant, he should have come within the period of limitation by filing a writ petition. That also was delayed.
my lord, what happened? I have filed one rectification application.
Under 161, na?
Yes, and that was not disposed of till.
You took the risk, sir. You file an appeal. Appeal before the commissioner.
Appeal before the senior joint commissioner.
Then this intra-court appeal by the writ petitioner is directed against order dated 19/5/2025 in WPA 21594 of 2024. The said writ petition was filed with the appellant challenging order in original dated April 29, 2024, passed under section 73 within bracket 9 of the WBGST/CGST Act 2070 for the tax period 2018-19 to 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 2021-2022. The learned single bench, after considering the factual position, had found that the proper officer has acceded to the request of the appellant and permitted the appellant to file their response to the show cause notice, which was taken on record and duly considered by the proper officer. Even after the adjudication order was passed, the petitioner did not immediately challenge the same by filing a writ petition, and it was filed belatedly and much beyond the period of ordinary limitation prescribed under the Act for filing a statutory appeal. In any event, the grounds which have been urged in the writ petition as well as in this appeal require adjudication into the factual position as to whether the officer acted in violation of principles of natural justice or not. The facts which fall for consideration are complex and complicated, and therefore the appellant should not bypass the appellate remedy provided under the Act. Therefore, we fully agree with the reasoning given by the learned single bench, and we find no grounds to interfere with the impugned order. Accordingly, appeal fails and is dismissed. The appellant is granted liberty to file a statutory appeal within 4 weeks from the date of receipt of the server copy of this order. And if the appeal is filed, the appellate authority shall entertain the appeal without rejecting the same on the ground of limitation and proceed to decide the matter on merits and in accordance with law. It will be well open to the appellant to place all the factual and legal issues before the appellate authority, which shall be considered. Sorry, sir. Next.
Deeply obliged to this.
Your Lordship, Mr. Kundalia appears in this.
Yes.
Item number 3.
Item 3.
Dismissal.
अच्छा 3 भी अपना
Take 4.
well my petition, my lord. In nutshell, my lord, I'm not opening the brief, my lord. I just late.
Yes.
My lord, it is as regards to disallowance of ITC, my lord. Now my supplier, my lord, has gone under liquidation. My lord, the issue is there was a difference of 41 lakh odd, my lord, out of which the supplier, the main supplier, my lord, Badrinan and Alloy, my lord, out when the supply was, the ITC involved was around about 39 lakhs, my lord. My lord, I was put into notice, my lord, for the month of...
order was granted subject to certain conditions.
My lord.
You are agreed by the condition. Why?
My lord,
10%.
I have all the documents, my lord. I have all the documents as regards to, my lord, to prove that the appellate order does not stand as per the provision of law, my lord. 16.2, my lord, says that...
This way the learned judge has called for affidavit.
But 10% is troubling me, my lord, as because I have already... I'm having all those documents. I have the confirmation from the liquidated suppliers.
You took the risk. Otherwise, if you had to file appeal lies to which authority? Senior.
I filed the appeal, my lord. After appeal, I've come.
And what is your next remedy available?
Tribunal, my lord.
Tribunal is yet to be. No.
Yes, thereafter, my lord, I came before you, Lord, before the single bench, my lord.
So if you had gone to the tribunal, you should have paid 10%. We have heard so and so. The learned single bench, while granting an interim order, imposed a condition that the appellant should deposit 10% of the disputed tax amount to be entitled for the order of sitting. Had the tribunal been constituted and the appellant had filed an appeal to the tribunal against the order passed by the appellate authority, the pre-deposit condition had to be complied with as it was mandatory. In the absence of the tribunal, the appellant has approached the learned court. We find no error in the exercise of discretion by the learned single bench for us to interfere. Accordingly, appeal fails. The time for compliance of the order passed by the learned single bench is extended by a period of 2 weeks from the date of receipt of the server copy.
4 weeks, my lord.
4 weeks from the date of receipt of the server copy of this order. Thank you. Next. Murshidabad Flour Mill.
Item number 4.
There is no time, sir, today. Not today.
The only issue is section 70.
Issue. You will argue and go who's to
No, I will not argue anything. My lord, your lordship has already recorded the detailed order, my lord. Beyond that, my lord, there is nothing left to argue.
Oh, AG is waiting for this matter.
But I have found this opportunity to appear before this court.
And you have to support the petition. But today is difficult.
My lord, your lordship has already, my lordship sees last order.
So that will, the next bench, which is a division bench, it will be easier for them to start from there.
No, my lord, already, my lord, your lordship has already decided the issue almost. My lord, kindly see the last order, my lord. Detailed order has been passed by your lordship. Detailed order has been passed, my lord. It is not a one-page order, my lord. Lordship has recorded everything, my lord. Whatever we had to submit and whatever was your lordship, my lord, the observation, it has been already, my lord, heard in detail, my lord. That is why I'm, my lord, saying.
So we have to hear Advocate General. So Learned Advocate General is going to support you.
Yes. Also kindly keeps it on Monday in that case.
All right, next week, let us see. The problem is if you reserve, I have got only one judgment on hand.
Yes, my
Today, only one judgment to be delivered. There is nothing pending. Today we have reserved that. If suppose I need to complete, need to complete that, then nothing is there.
Make it not today, my lord, in that
Let it
case.
be next week, my lord. Let us
All
see.
right. Next week.
I'm grateful.
Item number 5.
Item number 5, my lord, I'm appearing for the appellant. My lord recalls in the last occasion, it was submitted by the respondent that the agreement has been terminated pursuant to a letter dated 18 June 2020. And my lord, Mr. Ghoshal, a senior advocate appearing for this matter, he has sought for time to come back with instructions. My lord, my prayer is Mr. Ghoshal is out of the country for this week. Kindly keeps it next week.
This is that advocate for the appellant. List the matter on 18th September. Next.
Item number 6.
In this case, my lord, the issue is that a audit proceeding was initiated. The department called for several documents and record in the first step. We submitted all those documents. Thereafter, 5 officers visit my premises. But my lord, those 5 officers could have examined all the documents, everything.
You didn't treat them properly.
No, my lord, kindly.
If you had treated them properly, everything would have been.
No, my lord, I am the business of manufacture of industrial safety garments, my lord. Now, on the basis of my balance sheet for 5 years, they give an audit observation. Well, may I submit, my lord?
Petition. Volume 2. No, my lord. I am a little handicapped, my lord. There are 5 volumes. I don't have 1 volume of that.
No, I will hand over, my lord. I have all.
Now you challenge the adjudication order.
My lord, adjudication order, why, my lord? That because there is a total lack of application of mind and non-determination of at all stages, my lord. We submitted documents, my lord. My lord, kindly hear me for 5 minutes, my lord. The issue is that, my lord, for the
You'll have it next week. You serve the other volume. We have heard so and so, so and so. The learned advocate for the appellant shall serve the copies of stay petition on the learned advocate appearing for the respondent next week. 7.
But item number 7, I am appearing. But this is a GST matter, first year, initial year, my lord. With greatest respect, my lord, learned single judge admitted the writ petition and granted unconditional stay as substantial amount recovered before filing of first appeal. Around 76% of tax recovered. What happened, my lord? In the adjudication order, before adjudication order, my lord, show cause notice issued on the ground that in September.
No, how are you? Why are you filing an appeal?
There is no prejudice here.
My lord, this case is, my lord, subject to correction, my lord, subject to my submission, my lord, and lordship correction, my lord. That matter may be remanded to the adjudication. Why, my lord? Adjudication order passed. Thereafter, adjudication order dropped in December. Thereafter, they recovered. Then we filed appeal. There was delay in appeal. In the first round of litigation, learned single judge, my lord, condoned the delay. Thereafter, on merit rejected. And this dropping order was not in the knowledge of that learned advocate and petitioner. Thereafter, the case came to us. We searched the portal and found that July order already dropped, same show cause notice, in December. And reasons for issuance is that, my lord, in the September 2016 goods purchase. Thereafter, credit note received in GST regime. But I ought to have reversed the ITC. Instead of reverse, I added with my output tax and then adjusted with ITC. So this is no loss to department, my lord. And in the July month 2023, my lord, they passed the order.
Now, all these contentions you did not argue before the appellate authority.
Yes, my lord. Yes, that not our. That is why, my lord, my little understanding and prayer, my lord, matter may be remanded to the either adjudication or appeal.
I have been told, my lord, in the first round of writ petition also, he has not taken this point.
Yes, yes, I admit it. I admit.
Now in the second round, what I asked, what I had taken instruction, they said they had an issue with the module. They were also new to the. So what they had dropped is basically a singular module which they could not have done. But this has to be on affidavits. Today, the matter has come to a stage where there are factual dispute. I like to file an affidavit.
Then, if a show cause notice was issued, reply submitted, action dropped.
No, action dropped, my lord. It is
partially dropped.
No, it is not. What they say, my lord, what I also did not understand properly. There is a double module under which both show cause notice and adjudication order has to come. Here, in an instant case, it was done under a module which was only for the initiation of order. That particular was dropped. It was the proceedings remain. It was that some technical glitches or technical issues came up.
No, thereafter second show cause notice issue.
No, my lord. That's a first show cause notice drop in the second order and attach the first order. And kindly, my lord, have a look at 151 appellate order page, my lord. Page number 151, my lord. The appellate order, my lord. Para 5.2. They are also appellate authority also failed to understand, my lord. May I read, my lord, middle portion? Page 151, my lord. Para 5.2. My lord, middle portion, my lord. In course of hearing, he furnished tax invoices and credit notes. Upon checking such document with return GSTR 1 in the month of September 2017, it is observed that tax liability reported in GSTR 1 were such and such, while declared in 3B, CGST such and such. But it is not clear whether such enhancement was due to enhancement of outward supply or other reason. Furthermore, enhancement of outward supply due to reduction of input is beyond the scope of GST law. My lord, I have prepared one chart attached with my writ petition, my lord, page number 52, my lord. Kindly have a look, my lord. Page number 52, my lord. Para 26, my lord. Is continuation of para 51 that I have narrated in the chart, my lord. The particulars. September 2017 GSTR 1 output tax such and such. The September form 3B outward tax such and such. Difference 1,47,000, 1,47,000. Credit note receipt 1,47,000, 1,47,000. Department raised demand 156, 156. So as per my calculation, tax is payable 9814, 9814. But if I consider the recovered amount 2,37,000, then there will be the refund, my lord. And my lord, kindly have a look, my lord, the show cause notice once, my lord. I will take only 2-3 minutes time, my lord, not more than that, my lord. Kindly have a look, page 94, my lord. The page 94, my lord. The reference number, my lord, left portion upper side, my lord. 87977, my lord. Thereafter, my lord, our reply at, my lord, page 104. Thereafter, my lord, adjudication order, my lord, at page 114. My lord, 26 July 2023. My lord, in middle portion, kindly have a look. Serial number 2, the DRC 07 reference number 7977, dated 10 February 2023. Thereafter, my lord, this order, kindly have a look next, 119, my lord. dropping order 119. My lord, middle portion, my lord, show cause notice reference number 87977 dated 10th February 2023. My lord, I am reading middle portion, my lord. Order of dropping proceedings under section 73-74 with reference to the above referred show cause notice issued to you for representing your case against the reason stated in the annexure attached thereto on the basis of information available on record. The proceedings are hereby dropped for the reasons other details annexed in annexure, but they annexed the first adjudication order dated 26, which I have annexed next page, my lord. Thereafter, my lord.
No. First adjudication order means?
First adjudication order, page 114.
Page 120 is page 114.
Yes, 120 is 114 because they attach that order, first order, with the draft order. I have downloaded from portal, and this fact, my lord, was not known at the time of filing of appeal, because when change came to us, I personally searched the portal and found that the order is already dropped, and on dropped order they recovered the amount and already filed appeal, delay condoned, on merit appeal rejected. But this fact was
all right. In the memo of appeal,
yes, ma'am.
Have you raised this ground?
Yes.
In this appeal?
Yes. Yeah. And also writ petition also, second round of writ petition, where learned single judge granted unconditional stay. That writ petition I raised this ground. And
paragraph, which page?
Paragraph, my lord, at page 52, my lord. Starting page 51, para 26, my lord. And also credit note issue I have described, my lord, in the para 26, my lord. Page 51, my lord.
And what was the stand of the department?
Department also, my lord, appellate authority ought to have checked the portal before passing of appellate order.
But his explanation says there are two modules.
That is not reflected in the appellate order. This is a learned friend submission, my lord.
This is not instruction because the concerned officer is no more. Who has done it? The change officer, this is.
But then if you go by the reference number, it is dropped.
Yes, my lord. I cannot improve, but that is the difficulty. But my lord, today, my lord, he has not accepted this drop. He has filed an appeal. Kindly see the conduct. He has filed a.
Correct. But he says he is not aware.
Yes, I've mentioned.
But the facts, undisputed fact is, whatever was done in the reference number so and so was dropped on 10th of February. But in the annexure, they enclose the different order at page.
May suggest subject to my lord's remand this to the appellate authority because they will have all the papers.
No, because you have recovered about 75%.
Yes.
So that will be kept in deposit. Let the matter go back to the original authority, and he will adjudicate. What we can do is, he can give one more reply.
Reply, my lord, because
additional reply to the show cause notice covering all the points, including the appellate authorities.
Yes.
Then he will call for him and give personal hearing and do it.
And he will not take the point of limitation.
No, definitely.
Definitely. This intra-court appeal is directed against the order dated so-and-so and WPA so-and-so, in and by which the learned single bench found that the appellant had made out a prima facie case and granted stay of the demand, granted stay of the demand raised against the appellant, which was impugned in the writ petition. The learned advocate for the appellant submits that though the appellant does not have any grievance against the order passed by the learned single bench, which inures in favor of the appellant, it is the submission of the learned advocate for the appellant that on account of certain facts which were not within the knowledge of the appellant during the earlier round of litigation, and also when a statutory appeal was filed before the appellate authority, a prayer is made that the matter may be sent back to the original authority for fresh consideration. Full stop. It is further submitted that the interest of revenue has been adequately protected since already since nearly 70% of the
75%
of the disputed tax has already been recovered. we have heard the learned government council on the above submissions. Considering the fact that the dispute lies in a very narrow campus and the interest of revenue also stands protected, no useful purpose will be served by keeping the writ petition pending any longer, and it will be beneficial to both sides if the matter is remanded to the adjudicating authority for a fresh decision on merits and in accordance with law. With the consent of the learned advocates on either side, the writ petition as well as the appeal are disposed of by this common judgment and order. The appellant's contention is that the third respondent passed the appellate order and summary of demand and stated that the appeals petition stands disposed of and modified and directed to pay the tax totaling a sum of rupees 6,82,824. The appellant would submit that had the appellate authority checked the adjudication records and by calling for the same, the appellate authority could have ascertained that the proceedings initiated in pursuant to show cause notice in reference number Z capital D 1902230087977, page 94, was dropped by the proceedings of the Assistant Commissioner dated 10/2/2023. In the said order, which is in terms of section 73 of the GST Act 2017, dropped by order dated 11/12/2023, not 10/2/2023, 11/2/2023, under section 73/74 of the Act. The order states that the reasons for dropping the proceedings and other details are annexed to the said order. However, in the annexure, the summary of the order dated 26/7/2023 has been enclosed, but not the summary of the order dropping the proceedings. It is submitted that the appellant was not aware of this fact when he filed the appeal, and therefore it is submitted that had the appellate authority called for the adjudication file, this would have been evident, and the assessee and no recovery could have been effected from the assessee. Rather, the assessee would be entitled for refund, as according to the assessee, the total tax payable by them is only rupees 9814 under CGST and corresponding amount in WBGST. Considering all these facts, we dispose of this appeal as well as the writ petition by setting aside the order passed by the appellate authority as well as the adjudicating authority, and remand the matter back to the Assistant Commissioner, NS Road, Barabazar, West Bengal, for a fresh decision. In order to afford an opportunity to the appellant is directed to submit an additional reply. Additional reply with all facts and figures and the documents in support of their claim. On receipt of the additional reply, the concerned authority shall afford an opportunity of personal hearing to the authorized representative of the appellant, conduct a de novo proceedings, and pass fresh orders on merits and in accordance with law. While doing so, the adjudicating authority shall also examine the effect of the dropping of the proceedings pursuant to the order by order dated 11/12/2023 and other grounds that may be canvassed by the appellant. As mentioned above, 75% of the disputed tax has already been recovered. In the light of the order of remand passed in this appeal and writ petition, the said amount which has been recovered shall be treated as a deposit and abide by the final orders that may be passed by the adjudicating authority. The appellant is directed to submit the additional reply within 3 weeks from the date of receipt of the server copy of this order, after which the adjudicating authority shall fix a date for personal hearing and pass fresh orders on merits in accordance with law within a period of 6 weeks from the date on which the personal hearing is concluded. Next.
I'm grateful.
Eleven, 12, both places. I said 11, 2.
I'm grateful.
Letter number 1.
Oh, number.
Item number 8.
My lord, 8, I'm for the petition, my lord. Appellant, my lord. Here, my lord, 129 EOEVIL case, my lord. Here, what happened, my lord? I purchased iron goods from sale, government company. And from sale to Dankuni yard, goods came. Thereafter, my lord, for sheet cutting purpose, transferred to steel, Radha Vallabh steel processor. Thereafter, my lord, I regularly transfer my goods from here to my Uttar Dinajpur factory at Raiganj. What happened, my lord? In one goods, 2 goods carrying in the same vehicle. But while carrying, I was also carrying the EOA bill and also stock transfer note in lieu of delivery challan. Is tantamount to delivery challan. And also that's invoice generated by sale. But in the MOB 01, my lord, it's very important document for a statement recorded by the driver. That document attached. But which documents attached, what documents attached, not mentioned. Later, in MOB 04, they automatically say that one goods is okay, one vehicle is okay, and another vehicle, no documents. But later, in the show cause notice, they admitted, no, we have searched the EOA bill portal, there is EOA bill with stock transfer, that is delivery, tantamount to delivery challan. In the reply, show cause notice, after we submitted reply stating all these facts, the penalty imposed 200%, saying that you have not carrying invoice or delivery challan. Stock transfer cannot be the documents, but you are carrying EOA bill. They admitted. But my submission, humble submission is that in the MOB 01, it's very vital documents, ought to have mentioned what documents, but that was not mentioned. Nothing, no documents mentioned. Attached not. Thereafter, my lord, in the appellate authority, landed appellate authority stated in the appellate order that there is no evasion for payment of tax, no mens rea established. So reduce the penalty 200% to 100%. But law says either 200% or 0, my lord. This is the crux of the case, my lord.
Then, my lord, lordships has passed umpteen judgments. My lord, here is a case, my lord.
Very rarely the assessee succeeds before the appellate authority.
And my lord, there is a reduction. My lord, today, my lord, there is a reduction. তুমি বলেছো দাদা তো?
না হয়নি এখন বলা হয় my lord
No, reduction actually
It's a discretion, my lord.
no, there is no discretion. The discretion is only in cases where the 25%. You give the act.
25,000.
25,000.
That is section 122 subsection 3 clause E may extend to 25. That is, it may reduce also 1,000, 2,000, 5,000.
Section 129.
122. 120 integrated বের করেছে এখন general penalty. Yes.
122 also, 122. 25,000 of provision.
122E. 3E, my lord. For us, 1 week ago, your lordship passed one order. That fails to achievement in accordance to provision of that rules made thereunder fails to account invoice in books of account thereunder.
Which may extend to 25,000.
Extend to E.
Fails to issue invoice in accordance with the provisions of the act or the rules there or fails to account for an invoice in his bank accounts.
Yes. 25. But my in case, I will show your lordship the MOB 01. Kindly have a look, my lord. First the appellate order, my lord. At page 190, my lord. Question.
Lord, I'll request my lord to start with 189. I'll request with my lord kindly see the. Let me please. না তুমি দেখাচ্ছ অর্ডারটা আবার দুবার করে তো দেখবো টাইম কম আছে তাই জন্য বলুন
আমি করে দিচ্ছি, আমি 5 মিনিটে করে দিচ্ছি, উইদিন 5 মিনিটস। আমার উপরে ছাড়া আমি বোথ সাইড বলে দিই।
তাই বলতে হবে না, আমি আমারটা পারবো।
But the only thing they say is they don't accept the stock transfer because it is not your additional place of
My lord,
business.
that is why, my lord, I will show your lordship, my lord, the first e-invoice, page 82, my lord, from first. My lord, this is the 82, my lord, e-invoice. Invoice, my lord, your lordship knows that auto populated in my GSTR return, my lord. That is on 22nd April 2024, 10:30 to 14 hours, my lord. 3 goods were there. My case is, my lord, middle portion, 21.970 metric ton, my lord. Your lordship got, my lord, page 82. 82, middle portion. This is my case, my lord. Total goods, my lord, 65.450 metric ton. Thereafter, my lord, page 84, my lord.
Where do you get it?
My lord, the page 82, middle portion, my lord, the 3 goods, weight, truck number, and wagon.
Wagon, truck number.
Wagon number, yes, my lord. The 2 first goods, my lord, 21.780. Quantity, my lord. Second goods, my lord, 21.970, my case, second. Third is 21.700. Total 65.450. Consignor information, Bokaro Steel Plant, Jharkhand, to supply ship to Pushpa and Achievers, Uttar Dinajpur, Raiganj. This is e-invoice. Thereafter, my lord, we carried this entire goods at page 84, my lord. EOA bill. EOA bill that is related to this e-invoice, my lord, 82. Middle portion, my lord, address details from GSTN such and such Steel Authority of India Limited to, my lord, ship to, my lord, dispatch from Dankuni to ship to Radha Vallabh Steel Processor. Dankuni means, my lord, there are railway yard, and Radha Vallabh Steel Processor, that is in Dankuni also, for cutting purpose. Sheet, big sheet, these are big sheet for cutting purpose. So entire goods I have sent to them, 65.45. This is the EOA bill. Then, my lord, page 86, my lord. Page 86, my lord, some two mode of goods, first goods, third goods, already sent to the Raiganj, Uttar Dinajpur. But second goods, for some reason, I have stated in para 8 of the repetition that it was not, sheet cutting was not completed. But the protected my goods from rain and other weather damages. Thereafter, they issued job work invoice. For this is also e-invoice, much prior to my seizure, my lord. The 6 May 2024 at page 86, my lord. Thereafter, my lord, these goods, my lord, as page 91, my OA bill, my related this case, my lord. Kindly have a look, my lord. Page 91, this OA bill. When generated, my lord, 14 May 2024, stock transfer, Chalan ST3 dated, your lordship got, my lord, middle portion. Yes. Then from Pushpa and Achievers, dispatch from Radha Vallabh Steel Processor to Subhasganj, Raiganj, Uttar Dinajpur. This is inward OA bill generated. So this is not my additional place of business. My respectful submission is that that's for job work purpose. That job work supported by invoice, and also in throughout the year I do this.
No, this Raiganj is, what is that?
Raiganj is my factory, my lord.
So if first from the invoice was raised, it has gone to Radha Vallabha Steel Process, Dankuni for job work, and he has dispatched it by this e-way bill to your factory.
I brought, my lord.
You brought.
I brought.
You generated e-way bill and brought the goods to your factory.
And, my lord, this way bill, they are saying in the show cause notice as well as order as well as appellate order that in MOB 1, MOB 04, they are saying no documents submitted by the driver. But later they accepted. They are carrying this EOA bill and a stock transfer note, but not recorded anywhere that I have also e-invoice. Next, my lord, next page, my lord, the transport documents, 92. And this 93 is the, my lord, stock transfer voucher that mentioned, they later mentioned. This stock transfer voucher, my lord, this tantamount to delivery challan. Also, my lord, my invoice is there, but invoice not recorded. Not recorded this EOA bill also. Later they accepted.
But where from the appellate authority says that it is not an additional place of business. That is never his case.
No.
My lord, stock transfer voucher is issued only when a same entity is transferring to another unit. That is the explanation in the authorities have given.
But
Here, my lord,
the finding is very clear, sir. It is the goods were transported by valid documents. There is no dispute. And the appellate authority has found there is no mens rea to evade payment of tax.
yes,
Then he should have dropped the demand. I mean,
he has demand. Kindly for my satisfaction, just two things. Kindly come to page 189, just appellate order to that extent.
After learned spell, I will submit for 2 minutes only.
My lord would find just third paragraph. As claimed by the appellant, the cutting job of above shear coils could not be performed due to some technical issues. The coils remained in the premises of Sri Radha Vallabh Steel Processors till 3rd May 2024. Thereafter, Radha Vallabh Steel Processor issued job work invoices with respect to the above detailed shear coils, charging thereon storage and warehousing charges only in order to return the consignments to the appellant. The details of such job work invoice issued as follows. The difference in weight as per CR coil compared to the original weight by 120 to 220 kg is explained by the appellant is due to some extra packing on the coils by Sri Radha Vallabh Steel Processor. Now the above mentions here were dispatched by the appellant from the premises of Sri Radha Vallabh Steel Processor to its place of business at by using stock transfer voucher and generating e-wables as under. Now, out of the above three consignment, the consignment of so and so kg CR coil was detained and seized and penalized by the landlord on the ground that the said consignment was being transported without physical copy of the e-way bill and the appellant without having any additional place of business.
That theory itself is wrong. If you come thereafter, what he has done is they have examined how it has been done. Earlier also, Agarwal Steel Product Private Limited, they have given for job work.
Yes.
He has analyzed. Then at page 190, second paragraph. Now upon perusal of the above detailed activities observed, appellant transports the goods for his job worker to his place of business by issuing stock charter voucher or material in challan along with e-way. Present case, CR so-and-so transferred Dankuni to Raiganj without documents as per the order of AO. AO also mentioned in the order of so-and-so e-way bill had found generated for the consignment of stock transfer when verified e-way bill application. However, the appellant submits the goods, driver of the goods vehicle had produced upon interception before STO the relevant documents, original invoice, e-way bill, stock transfer with regard to this. Hence, the veracity both the learned AOs as well as appellant's claim could not be verified from the appellant. Now, upon a detailed perusal of the activities, appellant supported by relevant documents so-and-so, it is seen appellant transported so-and-so to his place of business by issuing so-and-so. That's a statement of fact. With respect to the instant case, there being no additional place of business, it is never his case.
And my lord, page 102, my lord, that MOB1, continuation 103. This is very vital, my lord. Documents attached, but at least also have written that what documents I have, that driver submitted, my lord. Kindly have a look, my lord. 103, my lord. That is very important. That ought to have mentioned. Later they admitted, no, they are stock transfer note, but also there is a e-invoice that is reflected in the will.
Now, who has submitted this?
my
Who
lord.
has prepared this document?
MOB 01, my lord. That the inspecting authority, my lord. First
So
inspecting.
according to you, he should have noted in the
Yes.
annexure
Yes.
those documents.
Those documents. And that is why, my lord, in the MOB 04, my lord, page 111, my lord, they are saying that one goods, they are saying that 15190, there are two goods type of. Page 111, my lord. 111, my lord. MOB 04. MOB 04, the two coil, my lord. One is 15190 kg. They are saying difference no. But here also they have not noted that what documents submitted. That is not. But in this case, they are saying the difference of goods because they did not note the what documents I have submitted. Later they accepted. This is the case.
This intra-court appeal has been filed by the writ petitioner, being agreed by the order passed by the learned single bench, directing the appellant to the bank guarantee alive and renewed till the pendency of the writ petition and directed affidavit to be filed by the department. The appellant being aggrieved by such direction has filed this appeal, and it is submitted that the writ petition, the scope of the writ petition lies in a very narrow campus, and the same may be considered and disposed of in accordance with law. With the consent of the learned advocates on either side, the writ petition as well as the appeal are disposed of by this common order, common judgment and order. The appellant had challenged the order passed by the appellate authority
Starting page, my lord, 176.
namely the Joint Commissioner of Revenue, State Tax, Raiganj Circle, dated 14/1/2025. The appeal filed by the appellant under section 107, challenging the order dated 19/5/2024, passed by the adjudicating authority, wherein 200% penalty was levied under section 129 within bracket 3 of the Act, was partly allowed, and the appellate authority has reduced the penalty after considering the facts and circumstances of the case. The assessing officer levied the penalty on the ground that CR coil of 21970 kgs was being transported from Dankuni to Raiganj without documents. This was disputed by the assessee, which led to adjudication being done by the appellate authority on the said point. According to the appellant, the driver of the vehicle had produced upon interception before the STO the relevant documents, namely the original invoice, e-way bill and stock transfer voucher with regard to the consignment. These documents were examined by the appellate authority and found to be correct. However, the appellate authority would state that since there is no additional place of business for the appellant, the transportation of the goods has to be deemed to be without proper documentation. And though there was no mens rea on the part of the appellant to evade payment of tax, since the goods were transferred to a place which was not registered as an additional place of business or a sister concern, imposed penalty at 100%. The appellate authority admits that the appellant has produced the necessary documents. Surprisingly, in form GST MOV
01, page 102.
Page
102.
10. We inform GST MOV 01 as recorded by the State Tax Officer, Bureau of Investigation, Raiganj Zone. In the annexure where the documents have to be mentioned, it has been scored out. In other words, it would mean that no documents were attached. This is factually incorrect and has been noted so by the appellate authority. Apart from that, from the annexures to the stay petition, we find that the tax invoice has been produced by the appellant, which shows which has recorded all relevant details which cannot be disputed by the revenue. The e-way bill dated 26/4/2024 also mentions that the quantity of CR coil at 65.45 metric tons, and it is to be shipped to Sri Radha Ballabh Steel Processor at Dankuni, who's the appellant's job worker. The goods were transported from the Steel Authority of India Limited. Upon completion of the job work, an invoice has been raised by the job worker dated 6th May 2024, which also clearly sets out all the details as well as the buyer's name, namely the appellant. A e-way bill has been generated for the purpose of stock transfer from the job worker's premises at Dankuni to the factory of the appellant at Chapudwar.
Chapdwar, Raiganj, Uttar Dinajpur.
Chapudwar, Raiganj, Uttar Dinajpur. Stock transfer voucher as dated 14/5/2024 has also been generated electronically.
This is manually, madam.
Has already been generated, which has not been disputed by the department.
And transport document, page 92.
Apart from that, the transporter has also, what is this at page 96?
96, 96, my lord, another case, my lord, that is not dispute. But transport document is 92, my lord.
And the stock transfer is supported by the document issued by the transporter, Subhatra Sarkar, dated 14/5/2009, where the goods have been shown, where the consignor is the appellant, the address given is that of the job worker, and the consignee is the appellant, and the place to be transported is Raiganj, Uttar Dinajpur. Thus, all the details will clearly reveal there was absolutely no intention on the part of the appellant to evade payment of tax, which has been admitted by the appellate authority. But however, the appellate authority erroneously did not set aside the penalty but reduced the penalty. Taking note of the peculiar facts and circumstances of the case which have been set out above, we find that this is not a case where any penalty could have been imposed. For the above reasons, the appeal and the petition are allowed. Order passed by the appellate authority as well as the adjudicating authority are set aside, and the penalty imposed is deleted. If any recovery effect,
there is, my lord, bank guarantee. That may be direction may be given. That renewed bank guarantee.
The appellant shall cancel the bank guarantee furnished in favor of the department.
Bank guarantee may be released, my lord.
And accordingly, the same shall stand released.
May I submit, my lord, the copy of bank guarantee? Latest. I'm grateful.
You give it to Mr. Thane.
My lord, one request, last request, Procedural. My lord, item number 18. My lord, item number Sir, item number 18, it is a review by the revenue. My lord, we are agree. My lord, one my lord, single matters what happened, where my lord lordships was pleased in one matter, asked us to refund. But now it is found, my lord, he had independently challenged in a writ petition.
Show 18.
18. My lord, Mr. Kanodia is not there possibly. So in his absence, I should not do it.
No, no,
But my lord,
we will not hear him at all.
Lordships, I'm there, Lordships, I'm there. Lordships, I'm there.
Give file number 18. We'll dismiss it, you take it on appeal. This is a very bad court for review.
But my lord, if my
You
lord,
are trying to re-argue, you are wasting
no, my lord, not re-argue, my lord. I'll
yes.
take 2 minutes. If my lord is satisfied for 2 minutes, thereafter, my lord,
That is
without
why we-
seeing the brief also, my lord, without seeing the brief.
What is the first? Let us see what was the order passed by us.
এখানে আছে মানে কি আমি নিয়ে But we have other part has been complied with. Only the part of 64 lakhs. Well, kindly just he had independently challenged in a writ petition which was dismissed. Before my lord, they came up.
They challenged.
They'll challenge in another writ petition, another my lord, which was not placed before this court at the time of. Where my lord was told that already we have recovered 20%, which 64 lakhs is part of that 20%. So there will be no further recovery. There had been no further recovery, and the matter was directed to be heard. He had challenged the authority of Bureau of Investigation who had issued the show cause. 20% was on that premise. There had been no further recovery. Now, my lord, by this order, the other order gets modified. The moment
the writ petition in WPA 2168
is a subsequent writ petition, and my lord, the previous where 20% was there was a previous writ petition. In this next proceedings, he has not disclosed these facts. Initially, the state was not a party. My lord, division bench, my lordships were pleased to ask the finance secretary to be made a party. There at that stage, my lord, there's something I have to say, my lord. If
I will clarify the position, Lordships. I will clarify.
Then you do one thing. You file a short affidavit.
Affidavit. Lordships, whenever a Lordships takes place, it will hardly take 5 minutes from my end to clarify.
All right.
Because my learned friend has submitted it.
I'll speak for
I beg your Lordship, pardon, my lord. But item 10, kindly keep it to you and sir tomorrow, my lord. My lord, kindly, I am.
Item 10, who will appear for the state?
My lord, I am appearing on behalf of the state. Well, kindly keep it tomorrow.
Submit to your lordship, it's an unauthorized construction. Your lordship's direction.
I will take.
Wait, sir. Please wait. You are the complainant.
This is the lordship's direction that the building to be demolished. The portions.
You come to say.
The portions were remaining. The portions were beyond the sanction plan to be demolished. The matter went before the Supreme Court. Supreme Court also upheld the lordship's direction. Actions had been undertaken. Day-to-day, the demolition work is continuing. And your lordship, on the last occasion, when I submitted report, your lordship asked me to give the detailed report. And I have submitted the report to your lordship affidavit, giving the day-to-day actions taken for 60 days. After taking when the last I gave it for 60 days, day-to-day, when what portions has been demolished, and the accumulation, the debris to be removed. Because unless the debris are removed, further actions could not be taken. In that 60 days, program actions have been reported to your lordship. And I have also expressed certain difficulties that because of congested area and scaffolding to be made. But it is continuing for a limited period. It could not be because of torrential rain and other things could not be done. But again, it has been commenced. This is the position, and it will be.
Now, the latest order passed by the Supreme Court, Honorable Supreme Court,
my lord,
I think day before yesterday or on Friday.
Oh, yes, the Supreme Court has said that the High Court should take such an action not for regarding the demolition of the another constitution. That Yellowstone order is also like that.
Now, see, they say that after initially you did something, thereafter no action.
No.
Kindly give me 5 minutes, 5 minutes.
Illogical seized my report.
Sir, please relax, sir. Please relax, sir.
Illogically seized my
And
report.
why are you raising your voice? Why are you getting agitated? Are you identifying yourself with that Sabuddin, your client?
No.
You are an advocate, sir. You are wearing a robe. Be calm. Otherwise, we will release the matter.
No, my lord.
But illogically seized my report, my lord.
My lord, kindly come at page 16.
16
Page
of?
16, my lord.
16 of what?
Page 16, my lord. My lord, page 16, my lord. Last part, kindly see. What the corporation says, the third floor building except southeast portion which is unauthorized still has not been vacated. So this department issued a letter on Ato to the concerned PS requesting to get the portion vacate as early as possible for enabling KMC to comply the direction of the Honorable Court. But then come to police report, my lord, come to police report, page 31. What the police says? Police says we have vacated. My lord, police says, my lord.
Who is telling?
My lord, who is telling lie? Who is practicing fraud upon the Honorable Court?
Sir,
Lord,
what is?
kindly see the order, my lord. Page 31, last portion. The occupants have already vacated their respective flats. On 6th May 2025, requisition was sent to the executive engineer.
All right, we'll issue a direction. We'll issue a direction within a week. You carry out the demolition. Police is ready to give you assistance.
My lord, both should be punished, my lord.
No, my lord. I oppose the appellant, my lord. I was directed by this honorable court to vacate the floor, 3rd, 4th, and 5th floor only, my lord. And I complied by 30th April 2025. And I handed over the vacant possession on 6th May. My role is over. And till now, videography is going on. And whenever it is required, I will assist to the Kolkata Municipal Corporation, my lord. There is no further role from my end. My lord, please come to the page number.
My lord, may I make
It appears that you are for.
My lord, I have one innocuous prayer, my lord. I represent the respondent number 10 in the my lord.
Who is he?
My lord, he is the person responsible who made the construction, my lord.
No, you go to Supreme Court.
My lord, only
They will
one
have lost
thing,
the
my
case in the
lord. My lord,
Supreme
only
Court, my
one
lord.
thing,
Yeah.
My lord, please come to the
The
affidavit against the report of the police filed on.
of KMC has filed a report stating that the 3rd floor of the building except southeast portion, which is unauthorized till has not been vacated. And the department has sent a letter on 16/7/2025 to the concerned police station requesting to get the portion vacated as early as possible for enabling KMC to comply with the directions of this court in its letter and spirit. The additional officer in charge, Watganj Police Station, has filed a report stating that in compliance with the order passed by this court dated 20th March 2025, a notice was served on the occupants on dated 26/3/2025 of the unauthorized portions of the subject premises with a direction to vacate the respective flat within 30th April 2025. It is stated by the officer in charge that the occupants have vacated the respective flats. And on 6th May 2025, requisition was sent to the Executive Engineer Civil, within bracket Civil Building Department, Borough 9, KMC, regarding information of ready to render police assistance to KMC for compliance of the order dated 20th March 2025 of this court. However, it is further stated that demolition proceedings have been started on 8th May 2025 without any hindrance and are still going on under videography. Further, the authority states that the police is ready to act as duty bound and being within the ambit of law and justice and ready to comply with any order of this court. We have also perused the report submitted by KMC, where they have given certain reasons which in our opinion are lame excuses and are to be outrightly rejected. Very recently, the Honorable Supreme Court has issued direction to this court to take appropriate and effective steps in the matter of unauthorized construction in Kolkata. Therefore, we direct the KMC to carry out the demolition and in advance write to the concerned officer in charge for deployment of adequate police force, and the entire demolition should be carried out, completed, and photographs be produced on the next. No further extension of time will be granted, and the demolition shall be completed not later than 19 September 2025. Let this matter appear on 26th September.
My lord, videography. My lord.
Yes. That police is.
My lord, only one thing I am submitting, my lord. That your lordship, of course, my lord, whatever observation made, my lord, I do not say anything. But my lord, your lordship, my report says that from 8th May, the last report which I have given to your lordship, my lord, from 8th May to 28th July, I have given, my lord, the portions, my lord, actions, my lord, the portions, my lord, demolished, and also on the regarding
That is appreciable, but the stand is that the police have already issued notice.
Well, only,
I have to submit
of
before
course,
your
my lord,
lordship.
but there is no difficulty,
One
my lord.
thing, my lord.
Kindly see
But
the last
your lordship, the time limit, your lordship, I have given, my lord. I will make, my lord, every effort to act, my lord, in terms of the only, my lord, difficulty is the around the building. There are, my lord, the small huts and all the other things. That, my lord, create some
All
problems.
this thought process should have been with the engineers when the unauthorized construction was carrying on. They patiently waited, watched, let it go on.
That was I did not say.
May I allow one thing, my lord? Till yesterday, corporation was stating that there is third, fourth, and fifth is illegal. Today, all of the sudden, corporation is saying that one portion of second floor is illegal. How it can be possible, my lord? Two type of submission made by the KMC, my lord.
Well, kindly see the photograph on last photograph. Kindly see the photograph. 25th August. Well, kindly see
The date and
kindly see. Kindly see the photograph, my lord. 25th August. Kindly see.
The learned advocate appearing for the applicant. Sir, be relaxed, sir. The learned advocate for the applicant submitted that the statement given by the KMC is absolutely false. And to support his contention, a photograph taken on 25th August 2025 at 11:17 a.m. has been produced, which prima facie shows that the building is in occupation and no part of it is demolition.
Before your lordship, I just may I have a small response. Item number 11. This is the contempt applications. The last occasion I have submitted that the Supreme Court is the cessation of the matter. And accordingly, lordship has directed to come up with an affidavit. The Supreme Court has
And who will appear for the applicant?
The last occasion nobody
Lord, I am item number 11. I am for the petitioner.
Any appeal to Supreme Court?
Appeal has SLP has been admitted, my lord, but no stay has been granted.
As against the order passed in the appeal in MAT number so and so.
No, they were supposed to submit a copy
An
of
appeal has
the
been preferred by the respondent, by the state before the Honorable Supreme Court in SLP number so and so, and the matter is pending.
What copy has been annexed in the last.
In light of the same, let the matter go out of the list. Liberty is granted to the learned advocates on either side to mention the matter after the disposal of the appeal pending before the Honorable Supreme
My lord, item number 10, what I was submitting, my lord. My lord directed the third floor, fourth floor, and fifth floor is illegal. My lord, the only difficulty is that the second floor, my lord, the ceiling of the second floor now is getting hampered.
It will be hampered. Let them file a criminal case against the builder. Sir,
And my lord,
all crime against society, sir.
And my lord, the waste material, my lord, that are being accumulated, my lord, there, it should be, my lord, removed, my lord. Now, my lord, the Kolkata
You
is, my
don't
lord,
have the courage to go to Supreme Court because you know that you have committed the mistake. We leave it at that. Yes.
May we permit you to mention, my lord, one matter for correction. This is for the fourth time, my lord, I have mentioned the matter. File has not. Can you see, my lord? Only one line that PLO instead of matter was disposed of long back. And for only this correction, my lord, has not been made. The inter order, my lord, is now in fractures.
What correction?
Correction means your lordship directed the PLO. It should be BDO. Only that correction. BDO can't be. Upon a public land, my lord, the construction has been raised. Your lordship directed to remove the same in this matter.
In which page we have said BLLRO?
PLO Namkhana, your lordship says it should be BDO.
You indicate in pencil.
Oh. Fifth respondent. Your lordship says fifth respondent.
Write it down.
Park it there. It should be BDO.
BDO where? Which place?
Namkhana. Fifth respondent. Fifth respondent, your lordship says.
Then case file has to be brought.
Yes, my lord.
So list next week for under the caption to be mentioned.
But may I be permitted to mention one matter, my lord? Not this matter was heard by your lordship, and the matter was directed to be fixed on 20th of June, lord. The matter was remanded back from Supreme Court, and your lordship, this bench was directed to hear the matter out, lord. This is I have annexed the order, lord, and also this matter was heard by your lordship, and it was adjourned till 20th of June, lord. But since then the matter has not come because your lordship is not sitting in that bench, lord. But today the matter has not been listed, lord. So.
And you have prepared the compilation?
My lord, I have already served upon them, lord.
All right, you list it next week.
My lord,
I'm grateful, lord.
may I be permitted to mention, my lord, that hot matter. My lord, the matter.
No time. Please call.
My lord, may I be permitted to mention one?
Which one?
This matter's point is very simple.
No. You can argue before lordship.
No. His lordship, on the day when the matter was taken up for first time, his lordship was of the view that this point has not been urged. And that's why this, I should say, is a mistake cropped up.
They have misinterpreted. They have misinterpreted our order.
That's the problem.
Stay is there, don't worry.
That was clarified. That was clarified in the subsequent
Clarified, but
order.
ultimately it's not been disposed of. Now this is not the law of the land. Law of the land is which my lord has decided and clarified.
Let us see.
I want to have it on 14th. So that, my lord, the last matter of mine.
No.
My lord,
First matter, last matter.
my lord, may I be permitted to mention one
That's why.
review application filed against the order passed by this.
Today we have not listed any review.
My lord, kindly constitute this particular honorable bench, my lord, to hear
Yes,
this
madam,
review.
please hear. Let me complete the sentence. Today we have not listed any review application. Only contempt petitions. We will list it next week.
My lord, may I
You
give this?
give.
I'm obliged.
Yes, please.
Daily state number 1.
Original side.
But I picked up for the petitioner.
First time it is coming.
No, your lordship, please to direct the petitioner to serve a copy. It has been served. A very innocuous. Well, let them inspect and say whether there is a construction or not. Nothing more.
So we directed inspection.
That has not been complied with.
12 weeks time was granted.
But I'm handicapped in the sense, my lord, the landed junior, my lord, has not devoted me to me, my lord, anything about this.
Should you keep the contempt pending or we'll extend the time? We making some very strong observation.
But one, let that not be done, my lord. I, my lord, taking it that next occasion, it will be done.
Justice, that is the best.
Next
This
occasion,
contempt application has been filed for willful disobedience of the order and direction dated November 27, 2024 in WPOP 3 of 2024. The operative portion of the order reads as follows. Page 2, bottom, paragraph starting thus till the end. In terms of the directions issued, the applicant petitioner has submitted another representation enclosing the copy of the earlier representation dated 24/5/2024, as well as of the copy of the order passed in the writ petition, and by personally appearing in the office of the Kolkata Municipal Corporation. In spite of the petitioner having complied with the same, the authorities of the KMC have not complied with the direction, though a time limit of 12 weeks has been stipulated. Very recently, the Honorable Supreme Court has expressed grave concern about several unauthorized construction which have been done in Kolkata, and this court has been directed to look into the matters and pass effective orders so that the illegal constructions can be removed. From the photographs annexed along with the application, more particularly in paragraph pages 61 to 63, it is seen that the construction consists of ground plus 1, 2, 3, 4, 5, 6. Ground plus 6 floors.
Plus 6.
The allegation made by the applicant is that the entire construction is wholly unauthorized. It is not clear as to why the officials of KMC have not inspected the building when the construction was going on. It is also not clear as to whether there is any requirement in terms of the orders passed by KMC to display the planning permission details by way of a board in front of the proposed construction. If such requirement is already in place and if the board is not installed, KMC can take action. If the board is installed, full details have to be given, and in the event and any official of KMC who passes by can verify with the ongoing construction with the details displayed in the board, which will clearly reveal whether there is any violation or not. Therefore, we may not be wrong in taking a prima facie view that the officials of KMC have turned a blind eye to such illegalities. Full stop. In any event, it is for the full stop. It would not have been difficult for this court to initiate action for contempt and also punish the officials, but that is not going to solve the problem and put an end to the illegal activity as alleged by the petitioner. Therefore, we direct the implementation of the order passed in the writ petition. Mr. Ghosh, learned senior counsel appearing for the KMC, submitted that KMC will comply with the order and the time may be extended. Full stop. Thus, considering all the facts and circumstances, the time stipulated in the order dated 27th November 2024 is extended by a period of 3 weeks from date. And the inspection should be carried out and appropriate action should be taken in the event it is found that the construction is unauthorized. With the above observation, the contempt petition is disposed of. In the event the respondent officials of the KMC do not comply with the direction within the time permitted, the applicant is granted liberty to revive this contempt application by filing an appropriate application for necessary relief.
Nowadays, after the sanction is granted, now the board is put up where the building is sanctioned. But some of the cases where it is not, That building is there, board is not there.
Board is not there because no sanction.
Sir, actually, what I have in Salt Lake area, none of the ongoing construction have got the board. Now, Lordship has informed me that rule is there. They have to keep the board.
That
None of the
is
construction.
the thing. Everyone
least-
should know, my lord, how much the sanction plan is there, what is the number of the sanction, and who is the
number of
developer.
sanction granted in whose name, his address, his telephone number, email ID.
LBS, name of the LBS and particulars of the LBS is also required.
Salt Lake is saved, my lord. My lord is taking the name of
No,
Salt
no,
Lake.
not in Salt Lake, within the jurisdiction of Kolkata Corporation also this requirement is in place.
Yes. But the places where my lord will not find any board, any nothing, only construction.
Mr. Ghosh, the completion certificate has been issued in this building.
Maybe.
In this particular building. Well, in this particular building, I do not know, my lord, whether it is my lord.
It appears
directed.
so from the photographs. You must have issued the completion certificate also.
Everything is possible.
If it is not sanctioned, my lord, complete service is not granted.
Should not be.
If it is not sanctioned, my lord, never complete service is granted. Never.
But I was doing a
Unless it is a sanction and in terms of the sanction building plan.
All right.
In law, he is correct. My Mr. Ghosh, in law is 100% correct. But in reality, it is not correct.
One paragraph you add. In the event of, upon completion of the inspection, if KMC come to the conclusion that the building is unauthorized or any part of the building is unauthorized, the electricity connection, if given to the building, and the water supply and drainage connection shall be cut off. Let us see. Next.
And not to
Yes.
I'm for the petitioner. There is a
At
delay.
item number 2, I beg to appear virtually on behalf of the respondents, my lord.
My lord, there is a delay of 145 days, my lord, in preferring the review application and in the
Well,
review-
what happened? What we disposed stuff on the ground of
My lord, it was dismissed on the ground of monetary limit. Later on, my lord, the department has found out that the monetary limit, if your lordship considers this person is proprietor of 2 concerns, if we add up the total amount, that is more than the monetary limit.
But if the see, it's a demand for.
It's a demand. The show cause is against the person, that is Mr. Shotandranaran Goel. He is a proprietor of 2 concerns. Now,
So 2 entities.
2 entities. Now, if your lordship kindly sees if your lordship kindly comes to page.
Show us the order passed by the
Lordship
tribunal.
kindly comes to page 143 once. Lordship kindly sees paragraph B, the para starting with capital letter B. Instead of Messrs. Sri Sham Trader, the duty is 83,34,346.
Correct, sir. Sham Traders has got a separate registration.
My lord, with that, kindly consider page 157.
And Lordship kindly comes
Serial
to page
number 7.
151. That is in respect of Baba Traders, that is C.
157, serial number 7.
It
He
is
is the
1 crore-
proprietor of Srisham Traders,
it is
Sri
1
Chandan Shah.
1 crore 27
It's
lakh
recorded in the
82,000.
order itself.
So if we take
you can't take because Sham, what is it?
Sham Traders.
Sham Traders.
Serial number 7, lordship.
Its proprietor is Sri Chandan Shah.
Yes.
But
and the other person is Satyendra Goel.
It is actually controlled by.
Now that is a different, that is a whole new case my learned friend is
Both the
making out.
concerns are actually controlled by Shotyendra Goel, and that is
Correct,
the
sir,
state.
but he has got 2 registrations, no?
My lord, Baba Traders is the proprietor
And
is
if your lordship
Somen
kindly
Das,
comes, if your
and
lordship
that
kindly comes to
that
page 81
forms the
once,
part of
the
appeal in
statement will
Casta
make it
4.
very clear that who is
That
in
has not
control
been
of the farm.
taken in review, my lord.
Sri Shomen Das appeared on 17/1/2011 and tendered his statement.
Rightly, the order in original deals with each of the entities.
Yes, yes, my lord.
This review application has been filed by the Customs Department to review the order passed in the appeal dated 12th July 2024. There is a delay of 145 days in filing the review application. Since the delay is not opposed, the same is condoned. Application in GA1 of 2025 allowed. It is submitted by the para. The ground on which the review application has been filed is that one person is in control of two entities, and the total demand of duty, and the demand of duty has to be calculated in total, and if it is done, it exceeds the threshold limit, and the revenue can pursue the appeal. Full stop. As could be seen from the order in original, each of the entities have been separately dealt with, and the demand has been confirmed in respect of each of the entities. Full stop. Though a single person may be in control of two entities, as long as the entity is a as long as the person or the entity is separate and distinct, the question of clubbing the two tax demands would not arise. Thus, we find no grounds to review the order impugned. Accordingly, review application dismissed.
Grateful, Lordship.
Grateful to your lordship.
Just call out Udayan.
Your Lordship, I just want to mention an order was passed by your Lordships on 28/2024. Till now, department has not given anything. They have come up with a review application, which
Where
was
is that?
the comment is there.
What is the review? Where is the review?
Your Honor, Lordship, if you go to the order now, your Lord.
May I clarify that? My Lord,
It is original side or appellate side?
Appellate side, your Lordship. The same.
Today we have not listed any review.
Yes, sir.
Next week we'll give. You give the number.
Much obliged, your Lordship.
Please call.
Appellate side matter, item number 1.
Yes.
My lord, I am for the petitioner, my lord. My lord, in view of your lordship's order dated 26 March 2025, my lord, contemptor, my lord, extended the pensionary benefit, and my lord, supplied me a copy of their compliance report on 20th May of 2025. My lord, from the compliance report, it is not, if there is no breakup on what account I am receiving such amount. But my learned, my client instructed me, he received a paltry sum of 8,688 towards pension, monthly pension. But the person concerned similarly situated under the same category who retired, they received 22,000 per month. My lord, your lordship's direction, kindly have a look to your lordship's order.
His case and other cases not identical, because your lordship can remember he was not a regular staff. But your lordship can directed certain.
I have not completed.
If he has grievances, he can take up that this is the amount he is entitled and this amount has been.
Page 5 of your lordship's judgment, my lord, running page 20. My lord, kindly have a look what your lordship's, my lord, held. My lord, page 5 of your lordship's judgment. It is enclosed in the contempt application. My lord, kindly have a look page 5 from third line. Insofar as the operative portion.
Sir, payment of pension is not in dispute. Quantum is in dispute.
Yes, my lord, your lordship say that the service rendered by the petitioner as a temporary, on the temporary basis under the same employer, that to be reckoned in calculating the total length of service. So my client served 18 plus years under the KMC as a temporary staff before being, my lord, absorbed as a regular employment by the same employer. So, my lord, it comes to.
But 1 second. The chief manager has given a report. That report contains no details.
Yes.
But exactly. But that my lord, he asked because that on the amount which has been mentioned there on calculation, he is, my lord, saying that the breakup has not been given, how it is calculated in having regard to a losses direction. But that could be provided. There is a difficulty. My learned friend has also not said to the authorities that he is entitled to such and such amount. Your lordship has not said any particular quantum.
No, we have not said.
Your lordship has not said any particular quantum.
Wait. There are two ways of doing it. One is we can direct them to furnish the breakup.
My lord.
And based on that, you can file your affidavit, etc. Or we can do one thing, we can direct them to furnish the breakup and give you liberty to challenge that. Because after 15th, to list this contempt application will be difficult. Okay. So if you take the second order, we dispose of the application. Within 2 weeks, they furnish the details based on that, because we have not fixed the quantum.
Yes.
We have said half service to be counted. So you keep the judgment intact. Based on that, you develop.
One thing, on the basis of your lordship's judgment, it comes to my lord.
That's right. But the thing is that the
service rendered by my client comes to 8 years as permanent plus 18 years.
Lordship has to go for single bench now. So therefore, if you want, we'll pass this order, or
whatever your
breakup,
lordship thinks fit, my lord.
consider.
This contempt application has been filed alleging willful disobedience order and so on and so on. A compliance report has been filed by the Municipal Commissioner KMC, but the compliance report is bereft of any details. The learned advocate for the applicant submits that roughly about 8,000 rupees has been paid as pension to the applicant, whereas similarly placed persons have been paid more than rupees 22,000.
22,000.
In the absence of any breakup details as to how the pension has been quantified, it cannot be stated as to whether the petitioner applicant would be entitled to more than what has been paid to him as pension as of now. In order to set things right, we direct the Municipal Commissioner, Kolkata Municipal Corporation, or any other authority who is in charge of the matter, namely the Chief Manager, within bracket SR and AC, pension, PF, GL, HBA, and staff quarter, KMC, is directed to communicate the entire breakup details as to how the pension was commuted, how the gratuity was computed, and how the adjustment was made, etc. Such information should be furnished to the applicant through speed post with acknowledgement within 2 weeks from the date of receipt of the server copy of this order. Upon going through the information and breakup details, if the applicant is aggrieved, it will be well open to the applicant to take further steps in accordance with that.
Today, Lordship, we wish to make one more week, my lord, extra, my lord. 3 weeks instead of 2 weeks, my lord.
3 weeks.
My lord, if your lordship direct to one copy to me, my lord, in addition to my lord petitioner, because petitioner shifted the resident.
Copy by receipt report to the applicant, as well as to the learned advocate on record for the applicant. Disposed of. Next. First.
Item number 2, well, in this matter, my lord, I beg to appear with the alleged contender, my lord, in respect of the election of the annual general meeting, more than 90% has been completed. My lord, I have
election
in respect of the Forest Management Committee.
Okay.
My lord, if your lordship kindly see the Boxer Tiger, next page, the Boxer Tiger 100%, and in some, my lord, 1, 2, 3, 4, there are some.
You will complete it.
My lord, we will complete it.
None appears for the applicant. Mr. Rudran will be. Also appears for the respondent state. A fresh complaints report has been filed, signed by the Chief Conservator of Forest, dated 3/7/2025, from which it is seen that in many of the places, the AGM has been completed 100%, and in the other places, partial compliance is being done, and they are in the process of completing. Thus, we find no willful disobedience of the order and direction issued by this court. In any event, we direct the authorities to conclude the proceedings in respect of all the districts.
My lord.
Next, disposed of.
Deeply obliged. My lord, the contempt is disposed of. Deeply obliged. Item number 3.
I am appearing first time.
What is the
my lord? Copy is not served, my lord.
What is the contempt? What was the direction? What is the?
Your direction may be kindly given to the concerned authority to serve copy.
All right, serve copy.
Item number 4. Item number 4.
None appears for the applicant dismissed.
Item number 5.
My lord, I'm for the petition. My lord, I'm only paying for not today, my lord. I am only paying for not today, my lord.
Why not today? Not today means never at all.
My lord, learned
I beg
senior-
to appear for the proposed contempt as though I have not been served as yet, my lord.
My lord, then kindly pass a direction, then I will serve, my lord.
Sir.
Grateful, man.
Item number 6.
Now, item number 6, my lord, I am appearing. Lord, in view of the lordship earlier direction, my lord, I have served the copy of the my lord contempt petition. Now, your lordship kindly come, my lord, your lordship order, my lord, page 25. My lord, there is a direction upon the my lord forest department to collect the my lord fees, my lord, for my lord illegal felling of the trees. And my lord, there is a direction upon the forest department to utilize the fees for plantation of my lord trees. My lord, page 26, my lord, last last my lord, as soon as the amount is quantified and intimated, the 10 respondents shall remit the same within 15 days, and such intimation given to the said amount shall be utilized by the forest department for planting sufficient number of trees in accordance with the ratio prescribed by the government by choosing the correct variety. Thereafter, after serving the contempt petition, they have supplied me the documents. They have said they have passed the order, they have collected the fees. Now, what they have said, I filed one application for Right to Information Act seeking the amount whether they have utilized collecting from the person and utilized for the plantation of trees. But in that statement, they have said they had deposited the account to the government. They had deposited that amount to the government account. You should kindly see page page 8.
That is because
that is,
rules of business does not permit them to do so. We can issue a direction now. That amount which has been deposited to the government fund be released in favor of the
My
government.
lord, kindly appreciate this. That has already been done. My learned friend is relying on a communication which itself indicates that after depositing the same in the government fund, the same has been utilized for the plantation of trees as directed. My lord, kindly sees the Right to Information Act, my lord, the information he has enclosed. My lord, kindly sees whether any deposited such and such, the amount deposited by the private yes. My lord, the lordship kindly sees this page. My lord, I am handing over.
Page number is on top.
The page number is 7 minutes. That is 7.
Page number
Page number
is
is 7.
My lord, the information given to the writ petitioner by way of, my lord.
Yes, deposited in government.
Yes. My lord, the deposited fund is rupees 13,350. How many trees? That is a part of your lordship's direction 100. What trees have been planted? That is also specified. And whether the forest department, yes, are utilized, deposited. Initially, that is deposited in the, that is the procedure. And after that, the same has been utilized for plantation of trees.
They have carted different number of different trees. You also kindly see 100 number of betel nut. They have carted mango and bought and also to all trees. They have planted only 100 number of betel nuts. That is not
that my learned friend
contention
cannot
of the
dictate.
order. You also kindly see for planting sufficient number of trees act in accordance with the ratio prescribed by the government by choosing the correct variety of trees.
which are suitable in the
Variety of trees. They have carted one
one plot and total plot, including the mango trees and all other big trees, and now they are trying to say they are only planting betel nuts. I'm not doing it. Well, that is the contention of the government. After cutting a different number of different sorts of trees, and they will plant only betel nuts, and around the area of the only the boundary side of the plots, then nothing will remain. All trees will be cut down.
This is wrong, sir.
My lord, kindly sees what trees have been planted. That is indicated here. My lord, kindly.
You produce your instruction. Why are you relying on his instruction?
My lord, kindly sees. দিচ্ছি নে ধর। My lord, Lordship will see the bottom of this page which I have handed over to your Lordship. Lordship may kindly sees the entire document, but the second page of the list of documents which I have handed over, the note that is highlighted, my lord. Species composition of the plantation will be Devdaru, Mahogany and Neem.
Now, your Lordship, kindly see. This is only 28th June 2025. Lord, I have
instruction is dated on 20th.
Lord, I have
Why are you fighting against them? What do they want? They want greenery.
Yes, my lord.
Why are you fighting? You are a forest department, sir.
Yes.
You should say, I am proactive, I will do it.
Yes, my lord, that has been done in compliance with your Lordship's order.
We will summon him now.
My lord, kindly
let him be here tomorrow. He will not go to the DFO will go to the correctional home.
My lord, kindly see.
This is the sort of attitude he has got in giving instruction to you. He will go to the correctional home, not to his home.
My lord, kindly appreciate this. Only one.
Not appreciation. Lordship, you should advise him properly. As a state council, you should advise him.
My lord, kindly sees. This is the latest instruction I have requested him to supply. But your Lordship's order has been complied.
Please don't. We are not fools sitting here. This is all beautifully dressed up. You brought that chicken mesh, green color, to photographs. Only thing the DFO didn't stand before the sapling.
My lord, may I file these documents by way of an affidavit?
We are not convinced,
my lord,
that the Divisional Forest Officer, Howrah Division, has complied with the order passed by this court in its letter and spirit. The photographs which has been produced along with the written instruction dated 14/7/2025 appears to be of very recent origin and probably doctored to be produced before this court to show as if the direction has been complied with. We fail to understand as to why the forest department should take such a stand, more particularly the divisional forest officer. When trees have been felled, this court directed that appropriate species in the appropriate ratio should be planted. The forest department should have taken the matter with utmost seriousness and should not have treated this litigation as an adversarial litigation, and the manner in which the learned government advocate contests the matter based on the written instruction given by the divisional forest officer shows that there is something more than what meets the eye. Therefore, appropriate remedial steps be taken, and the various varieties of species of trees should be planted, and a compliance report duly supported with photographs should be submitted. Let a copy of this order be forwarded to the Chief Conservator of Forest, Public Grievances, Law and Information West Bengal, so that the order and direction is complied in its letter and spirit. Next.
My lord, made it returnable. Contempt application disposed.
Next.
My lord, it's the same matter, my lord. I am relying on same instructions because that has been
same order in the next matter also. You please advise him, sir.
My lord, you understand.
See, when they come to you, you take control.
My lord.
They shouldn't take control. You are all senior people in the panel.
My lord, you understand.
In matters where falsehood is said, they suppress material facts, you contest.
My lord, I understand.
See, you please be, you
My
are not appearing in the matter.
My
You see the photograph?
My
It is taken 3 days back.
My lord, may I get the appropriate clarification and come back before your lordship with
You
the
tell them.
My-
Tell them.
Next.
This is my petition, my lord, for contempt. It's regarding, my lord, the subsidy payment of subsidy matter. My lord has, my lord,
What happened Supreme Court?
the Supreme Court, the SLP dismissed. Now they have preferred a review. Now the review is not today listed. And in the meantime, my lord, what they have done, they have enacted a new law by which all the judgments passed in respect of this have been rendered to be.
And they have challenged that. They have
And now the
challenged-
virus has been challenged.
No, that you can do. But there are some judgments in your favor, some in their favor.
Yes, my lord, both ways, my lord.
Both ways. So,
my lord, it is good. My
our
lord
point-
is smiling. My lord, my lord got so angry. I have not seen my lordships to get angry. So
No. See that DFO, that fellow, there is something more, some personal animosity between his client and the DFO. Yesterday he has put up the net, and your friend is with a dagger in his hand. He is fighting.
But I am not so vociferous, unfortunately. But this is the new
Sir,
statute.
we'll close the contempt for the present.
Yes,
my lord, in that event, my lord, since my virus challenge is still pending, and one of the principal grounds is that judicial functions can't be, mandamus can't be taken away by way of a statute.
That you argue.
Yes.
You argue.
My lord, I was only suggesting, my lord, kindly gives me liberty to come back, my lord, in case I succeed, my lord, in the.
You can't come back to me, sir. It can't. It won't
But
be listed.
whoever, my lord,
It won't be listed, sir. And we are becoming popular for the wrong reasons. Calcutta High Court. How do we distribute these matters? 5,000, 10,000 contempt application pending. No advocate is appearing. You go to Justice Rashri Bharadwaj and ask the retired judges contempt, elevated judges contempt. Nobody appears. But the CIS it shows. And what is the image Calcutta High Court has got outside India or the rest of the states?
Well, kindly appreciate
This
in case I
contempt
succeed in the virus,
application
my
has
lord,
been
then.
filed, challenging the willful disobedience order and so on. So the state has enacted a validation act, thereby contending that all the judgments, the core of the judgment, the subject matter of the judgment will no longer be invoked in the light of the new enactment. Admittedly, the applicant has also filed a writ petition challenging the vires of the new enactment, namely the revocation of West Bengal incentive schemes, blah, 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 Act 2025. The light of the above, contempt petition is closed, leaving it open to the applicant to take appropriate steps if need be after the disposal of the writ petition.
I'm grateful, my lord.
There is the review.
No, review is before the Supreme Court. Review is pending.
No. My lord, review of my this division bench's order post dismissal of SLP.
This review application has been filed to review the judgment so and so.
Followed by
Admittedly, as against the order passed by the division bench, the state preferred an appeal to the Honorable Supreme Court, and the special petition has been dismissed. We have perused the grounds raised in the review application, and we find the grounds are not grounds of review, but they are grounds of appeal, and a review cannot be filed as an appeal in disguise. This being the settled legal position, no grounds are made out to entertain the review application. Dismissed.
Grateful, my lord. Deeply.
Next.
Not on my court.
Passed a law. You have enacted a legislation.
Review petition kindly.
No. You have got the new law. They are not going to get 10 paise out of it. Next.
Grateful, my lord.
Item 9.
I'm for the petition, my lord.
I beg to
The
appear.
villagers are before lordship since 2022 to have a usable road. This court was pleased to direct the DM to take decision. DM took decision. Then for implementation, second time we came, there was a direction.
Now you have served copy.
This is the contempt. They are appearing. Earlier they said some fund has been sanctioned. Now there we
At
can,
the outset, my lord, I pray, my lord, unconditional sincere apology, my lord. What has happened, my lord? On 21st January, my lord, we filed an affidavit, my lord, with some, my lord, inadvertently with some documents which is not related to this matter, my lord. We filed can application 1 and 2 for recalling of the order and to file a fresh affidavit on the context of this matter, my lord.
That affidavit is ready, fresh affidavit?
Yes, affidavit also ready, my lord. We accordingly, my lord, pray for modification of my lord's order dated 21st January 2025.
According to you, which order has to be recalled?
My lord, 21st
20
January 2025.
21st January.
Yes, ma'am.
Where is that order?
My
first
lord,
in this contempt.
in this contempt, my lord, it is appearing as at page, my lord.
What you say, we will get that affidavit? Where is the new official affidavit?
New application is lying with my lords.
Application is right. In this application, you have given the correct facts.
Yes, my lord. From page.
Have you gone through this, sir?
Yes, ma'am.
So we can recall this order and you file your response to this affidavit.
But ultimately, they said this were ready. We are ready.
Sir, they don't want all
But
your
this is
affidavits,
going on, my
They
lord.
want a road,
My
sir.
lord, my lord, earlier affidavit, we annexed the document saying it is a Pathasri Prokolpo that this amount was required to be sanctioned, my lord. We find, my lord, other letter, my lord, by which the block development officer asks us to inquire, and we have already, my lord, made a proposal to the block development officer, my lord. Kindly have a look.
All right. See, these statistics they don't want. They want road.
Yes, my lord.
Yes or no, you tell.
Yes, my lord, kindly come to page 29 for once, my lord, can application 1. Last page of the can 1. Last page. Last. My lord, this is the first item, my lord. This should be the amount, and this was informed to the my lord, in response to email of the block development officer.
7 feet wide.
Yes, my lord.
7 feet width.
Yes, my lord. This
7 feet will be sufficient.
Serial number 1, my lord.
Then you do one thing, sir. You file your affidavit to this can. That is better. The respondents are directed to file their affidavit in opposition to can 1 of 2025. 3 weeks.
7 feet,
Next.
1.8 meter. 8, 1.
I'm going to tie us 7 feet.
Wait,
Less than 7 meters.
Great.
Affidavit service, my lord.
Same.
No, affidavit of service.
That you give. Item 10. Who's for the applicant?
Lordship, I am for the applicant.
What is the contempt?
Lordship, on the last occasion, Lordship, the order was passed to consider the representation, Lordship.
What happened?
Lordship, the respondent number.
What is latest?
This is the report, my lord, already, my lord. Submit the report.
One copy.
My lord, I'm giving copy to you.
You give us copy.
Pursuant to Lordship direction, my lord, spot physical inspection was made by the BLR, my lord. I have given the.
Why your client didn't appear, madam?
Didn't
You
appear,
see
my
the
lord.
instruction? Last but one paragraph. Instruction.
Yes.
Neither the petitioner nor any private party has appeared for the hearing. Page 1. Page 1.
First page.
Madam, page 1, madam. Now you passed an order?
Yes, my last page is the report, my lord.
All right.
This is the report, my lord.
In terms of the order directions issued in the writ petition, an order has been passed by the BL and LRO, Barakpur number 2, dated 7/5/2025. If the applicant is aggrieved by such order, it will be open to the applicant to challenge the same. With the above observation, contempt applications disposed of. Next.
My lord.
Call.
Item number 11.
11.
11, my lord, I am.
My lord, I am appearing on behalf of respondent number 17.
My lord, I am for the applicant, my lord.
So I'm for the ADDA.
That earlier occasion, lordships are pleased to file affidavit by the state that state admittedly that their land, public land has been acquired for purpose of multi-storied building by the promoter, my lord, and there was
Directed the BLLRO to inquire into the matter. After conducting a joint inspection, with the officials of the forest department.
That has been done, and earlier occasion, senior
Where is
friend,
that?
my lord, so last order, to state
Where
to
is the
file
If I am
affidavit.
for the ADD, I am not a contempt. I was a party in the writ petition. That's why I have been served.
Now, has to file a?
Unfortunately, the original affidavit.
Doesn't matter. You show the copy. Now inspection is over.
The inspection is over. I understand this is sent to the concerned officers for consideration.
My lord, in this case, my lord, they are file, my lord.
Where is the affidavit? What is this? No. What? Where? Give it to him. Take the affidavit. What is their stand?
File. Okay.
You have been served?
No, my lord. My lord, I want to file, my lord, objection, my lord, because, my lord.
Sir, the direction issued was to inspect. We have not gone into the merits of the matter. If he passes an order, if it is against your interest, then you challenge it. This is an innocuous mandamus. And we are to have 15 hearings in the contempt application.
My lord, earlier occasion, my lord, that.
So did you communicate the order? Not the affidavit, sir, the order.
Nothing is done, my lord. My lord, earlier
This
occasion,
contempt application has been filed. The alleging violation of the order dated 22/2/2024 in WPAP 58 of 2024. The writ petition was disposed of without going into the merits of the matter by issuing the following direction, para 5 and 6. A draft affidavit filed by the to be filed by the DM not required, and collector Paschim Bardhaman has been produced, from which it is seen that inspection has been conducted and the officer has stated that immediate compliance of the order has been taken. Let the district magistrate and collector Paschim Bardhaman pass an order with regard to the action taken by their by the various departments in the district pursuant to the direction issued in the writ petition, and communicate the same to the applicant within 2 weeks from the date of receipt of the server copy of this order. If still the applicant is aggrieved, it will be well open to the applicant to avail remedies in accordance with law. With the above,
My lord, a copy be served upon me also, because I'll be the affecting party. Respondent number 17.
As well as the 17th respondent.
Yes, lordship.
In the contempt, what is your rank?
Not contempt, my lord, we are not made party.
Then forget it. Next.
Item number
12.
Made, please, your lordship.
Kindly, your lordship will allow me to place the report, your lordship.
Complied with?
No, my lord.
And your lordship, kindly consider the second page of my report, your lordship.
You give copy to your friend, sir. See, you are giving this written instruction. He should know what is the.
But these are the private lands, lordship.
Should you not communicate to him? The BDO, whatever he
There
has
was a
said.
specific direction over the video, my lord.
Pardon?
There was a specific direction over the video, my lord. It's at page number 22.
Petitioner already completed the brief,
You
your
communicate the order.
lordship, my lordship.
This contempt petition has been filed alleging willful blah blah blah. The operative portion of the order reads as follows: the block development officer Shardigi Sagar Digi, Murshidabad, has filed a report stating, and in the operative portion, it has been stated as follows. So, page 2 of the report, 1, 2, 3, 4. In the light of the above, the contempt application is disposed of by directly the block development officer, so-and-so Murshidabad, to communicate to pass an order and communicate the action taken pursuant to the order passed in the writ petition to the applicant within 2 weeks from the date of receipt of the server copy of this order by speed post with acknowledgement. If still the applicant is aggrieved, it will be well open to the applicant to avail other remedies in accordance with law. Next. 13.
I'm for the applicant. I'm filing the service.
I beg to represent alleged contempt, my lordship. Alleged contempt, my lordship.
Well, the order has been passed on 19th of September 2024, and your lordship was directed to.
Well, kindly comes to my lord, page 20, my lord.
Directing BLLRO to conduct one more inspection. In that inspection, concerned local body, panchayat, municipality should be directed. After notice to respondent 7, 8, 9, other persons mentioned, written instruction. Illegality found, construction should be stopped, direction come.
So, my lord, principally twofold directions were there. One is they had to hold an inspection. Yes, yes.
Lordship.
Inspection.
Madam, we cannot decide more than that. It is not a suit court. We can't put to somebody in the dock.
Lordship,
Lordship, may I respectfully invite your lordship to page?
not complied with.
Pardon?
Number 8, 7 was complied with. It's partially complied, but the needless than the state that if there is any illegality and if it is not found, the construction is proceeding, the same should be stopped forthwith. That has not been stopped yet, my lord. This is the pictures, and the illegal conversion of this land is the same position, and it is also unauthorized construction was going on, and that illegal conversion. That has been
And what do you have? Twofold directions. One is inspection. Milord 50, page 50 to 52 of my milord.
We'll agree, sir. All you did correct.
And secondly, illegal construction part. Milord kindly sees milord page milord 55 were written to the concerned authority because it's an illegal construction in the panchayat area. So milord lordship knows milord panchayat should undertake the process of demolition. Milord, this guy, this DLLRO, page 55, writes to the executive officer that you take proceedings in accordance. That is Panchayat Act.
Continuing, my lord.
What to do, madam?
No, it
they
is
are ready. They cannot stop. What he says is, we will direct the panchayat to take action.
Lordship.
Panchayat is not a party.
Not a party. The only alleged contempt is BLNLRO. Even in the original proceeding also, this panchayat was not a party, my lord.
This contempt application has been.
The liberty to.
No, you hear the order.
No, in the originality, he was not the party.
Operative portion of the order. The report has been filed with the block land and land reforms officers, Consequential 2 at Kolkata, dated 28/2/2024, from which it appears that the first limb of the direction has been complied with. The contention raised by the learned advocate for the applicant is that there is another direction issued in the writ petition, direction action to be taken against the illegal construction, illegal and unauthorized construction, for which no action has been taken. Certain photographs have already also been produced before this court. As could be seen from the written annexures to the written instruction given by the PLLLRO, a communication has been sent by the District Land and Land Reforms Officer Purva Medinipur to the Executive Officer Kolkata Panchayat Samiti on 6/1/2025 to take action under the Panchayat Act and the rules against unauthorized construction. However, since it appears that the order and direction, it appears that the same has not been complied with till date. In the light of the above, let a copy of this order be forwarded to the Executive Officer Kolkata Panchayat Samiti, Kolkata Purva Medinipur, with a direction to the said Panchayat to comply with the order dated order passed by this court and also the findings as recorded by the Block Land and Land Reforms Officer, Pankura 2, Kolkata, after notice to all concerned. In order to ensure that the order is complied with in its letter and spirit and appropriate action is taken, let a copy of this order be forwarded to the District Magistrate Purva Midripur by the registry of this court, so that the entire matter can be monitored. Full stop. Action be taken by the Kolkata Panchayat Samiti within 4 weeks from the date of receipt of the copy of the order to be communicated by the registry of this court.
No, bless you.
Let the report may be retained.
Report may be kept on record. Photo may be given back. Next.
Grateful.
14.
Item number 14. The 14, my lord.
First time.
First time. Now, this is my duty to mention before lawsuit. Your lawsuit directed on 2nd July 2024. But there's a time to file the reply to the so-called notice customs authorities. It is the customs authority decision. Then your lawsuit extend the time for 2 weeks. Then within that extended time, you file the reply. Now your lawsuit given then time for within 2 weeks from the filing of the reply to dispose of the proceeding. But they waited. They passed the order on 24th July 2025. Did not carry out your lawsuit specific direction. Remind him.
That is why Supreme Court says, if there is no deliberate disobedience, contempt you don't take. Now you challenge that order. We will give liberty. The order and direction issued by this court.
But I have copied you. They ought to have
complied with, but belatedly. It is of course, it is true that this court is well open to this court to initiate appropriate action for contempt. Nonetheless, since we find that there is no willful disobedience, there are no action for contempt should be taken. So is required to be taken. The Additional Commissioner of Customs Preventive, Kolkata, has passed an order on 24/7/2025, and if the applicant is aggrieved, they may prefer an appeal to the Commissioner of Appeals of Customs, Kolkata, with the offers of liberty, contempt application.
But you basically give some time. That order, my lord. Now we're waiting your lawsuit because contempt, my lord. But I think give some liberty.
Some time.
Some time.
If the appeal is filed before the Commissioner Appeals within 15 days from the date of receipt of a server copy of this order, the appeal shall be entertained without rejecting the same on the ground of limitation. Next.
Item number 15.
My lord, item number 15 is also appearing for the first time. My lord would remember this is that matter, my lord, in which one employee of a bank was transferred 3 times in 3 weeks.
Yes. Now what happened?
Now, my lord, pursuant to your lordship's order, my lord, your lordship has protected me from transfer for a period of 1 year. I am not being transferred. Because pursuant to that order, now if you transfer me, you have to give me promotion. That's settled. Now the only issue is with regards to the TA and DA bills. That is pending. I'll be candid to your lordships, my lord, kindly takes up...
Serve notice.
My lord, kindly takes up page number 7.
You serve notice.
I will. But then there has been a change of the zonal manager.
Oh, then you have to correct the cost.
Yes, I have to correct the cost item.
All right.
And also, my lord, may this be kindly recorded with all fairness, my lord, that they have paid me, they have made a part payment of rupees 24,000 and odd, and they are now saying that you again apply online, whereas, my lord, the online portal is time barred, so that is exactly what is preventing me from applying online. They have paid me 24,063 rupees. I have received another communication yesterday from their office. They are saying that we will pay you. Now you apply online, but then the portal in that case has to be amended accordingly so that I can. Because the time limit has already elapsed.
Leave is granted to the learned advocate for the applicant to change the name of the first respondent alleged contempt.
Yes.
Zonal manager. Since the zonal manager has now changed.
From Mithilesh Kumar to Mrityunjoy Das.
Whatever it is, you correct it.
Yes.
The learned advocate appearing for the applicant submitted that a TA bill to the tune of rupees 24,063.10 has been sanctioned. Remaining bills, and in respect of the remaining bills, the respondents are willing to sanction, but they want the applicant to apply online. However, there is a difficulty in accessing the online portal,
which has also been indicated before filing of the contempt petition.
Let a copy of the contempt application be served on the respondents / alleged contemnants, as well as a learned advocate who appeared for the respondents when the writ petition was heard, along with a copy of this order.
Grateful.
List after so and so. Next.
Grateful.
Item number 16.
My lord, I am led by Mr. Vivek Tripathi, who is appearing on behalf of the petitioners. Is the
For the
duty
co-
less?
I am for the
Let us see
corporation, my
whether
lord.
they have complied or not.
Order has been complied with. Regarding my lord,
What is the order? What is the
representation to be considered after giving inspection, and thereafter reasoned order is to be passed. That has been done, my lord. Inspection has been done, and my lord, second thing that has happened, my lord, reasoned order has been passed, and it was found that the unauthorized building.
to do demolish? You give copy. The order and direction is we have heard so. Learned advocate appearing with Aura Municipal Corporation submitted that the order has been complied with. Inspection was conducted and unauthorized construction was found, and show cause notice has been issued to Papu Burma dated 9/8/2023, and thereafter order has been passed on 24/3/2025, directing
Self demolition, my lord, as per 177.
Demolition of the illegal construction within a period of 15 days by Papu Burma himself. It appears that Papu Burma has not carried out the direction. In such circumstances, we direct the Howrah Municipal Corporation to take further action to demolish
in accordance with the act,
unauthorized / illegal construction,
because we have to collect the fees from them also.
After following the procedure stipulated under the act. This direction will be complied with within a period of 6 weeks from the date of receipt of the server copy of this order. Next.
Disposed of. Then will a contempt application be dropped and rule be discharged?
Rule not at all issue.
Discharge. Grateful.
Item number 17.
Well, in this time, I have. Well, initially, your lordship direction remove the cutter within 7 days. Contempt was filed. They file a purchase. They will take step. Therefore, your lordship direction kindly see my last page 41. Page 40. Your lordship has given the direction. Paragraph 3.
Cut all temporary structures, asbestos sit, recover the cost. Direct the municipal authority to.
Till today, they did not take any step.
And who appears for the municipality?
Municipality on the Kaushik Sen, my lord.
You serve notice on the respondent. Notice. As well as to the council who appeared for the respondent.
Matter will appear, my lord. Matter will appear.
After 2 or 3 weeks, it will come. Next.
Item number 18.
18, I am for the petition. The first time.
Serve notice. Yes.
Item number 19.
May it please your lordship, I am for the contempt. Order has been complied with. My lord, this is our report, my lord. If another person filed a application before the Green Tribunal in respect of the self-same property, and compliance report also filed before the Green Tribunal.
One copy you can give.
Yes, a copy.
This contempt application has been filed alleging disobedience of the order and directions also. Operative portion of the order reads as follows. Please quote that paragraph, sir.
Lordship,
You take whatever you
Lordship,
want.
by it's Lordship fine.
Data fix. It has report net, yeah.
The report has been filed by the executive
Lordship.
engineer, E&H Department, KMC. Stating
Lordship,
that.
kindly look at the order passed by. It says that issue notice upon the private respondent, conduct inspection, thereafter proceed according to the law. On 2nd of August 2025, they are giving notice to the contemner private respondents who have built
Now,
house on
you see this instruction given today, first page, last but one paragraph. As the owner did not pay heed, notice FIR, department resorted to fill up the portion of the hatch in the map at its cost, photograph so and so, sketch Diamond Club Behela is away from the water body. At present, it has been dismantled.
Lordship, it says that it has been done according to NRSA aerial map. The
Second page, you please see. The sketch filled up with rubbish,
That has been
presently
cleared.
arrested.
Cleared. That has been cleared.
And Green Tribunal, page number 3.
This is the order of the Green Tribunal.
So a report has been filed by so and so, dated so and so.
Lordship,
Stating that stating
Green Tribunal, the order is not final order, Lordship.
See, the problem is, sir, you should communicate what has action taken. 90% of the problem will be solved. None of your officers communicate to them.
Lordship, later,
how
let
will
me come back because I have to read it.
you don't read? You can't come back to me. Read it so and so. Apart from that, it is submitted by the learned advocate for the alleged contemner that already an application was filed for the self-same relief before the National Green Tribunal and a report has been filed before the tribunal as well. The placing the report on record, the contempt petition stands closed, giving liberty to the applicant to proceed afresh in the event, according to the applicant, still there are issues to be resolved, which have not been resolved by the KMC. Next.
Item number 20.
My lord, 20. First time.
My lord, this is
Sir,
the first.
Serve notice.
Much obliged, my lord.
Next.
Item number 21.
21, my lord, first time, my lord, appeared.
There is an application. After a long time, I could see your lordship.
Because we
Both
have
of you
become
are-
exclusively revenue bench. That is why we are not, I am not able to see all of
That is in your, that is by the volition of your lordship, not our volition.
Correct.
My lord, there is an application. I am not appearing in the contempt matter.
By the LR.
Complied with.
We have complied with.
Where is the complaints report? You give copy, you give. You want
Before,
to
before getting copy, the authority has complied with.
Instruction, as per
DM South.
my client, my lord, no
So,
complaints.
This gentleman.
Show that.
Lordship. My lord. Only one hotel was found to have encroached.
All majority of the DMs in
Yes, Lordship.
West Bengal are very effective.
My lord, then kindly, my lord, adjourn for the day, I will take instruction. My lord, adjourn for the day, only. My lord, I will take instruction from my client.
Very difficult to list the matter.
So DM directed for removal encroachment, thereafter SDO did it. My lord, he framed five issues. Lordship's direction was that he consider representation.
But he did a thorough exercise.
Yes, thorough. Kindly sees, my lord, page 5 of the report by the DM. He framed 6 issues up. Thereafter, he found only 2 are found to be yes, rest are no.
Madam, your client was represented by advocate.
Yes.
My lord, that is true. My lord, only my lord regarding one hotel, my lord.
To challenge this order.
demolition-
Yes.
demolition order is passed. Already demolition order passed, and direction has been given to the SDO to compliance.
It has been done.
Kindly give me a short time, my lord. I will take instruction if
All-
that was complied or not. My lord, kindly. But that is in.
Now, kindly
the discreet.
That is in
All
favor
right.
of me.
This
My lord, absolutely.
contempt application has been filed alleging willful disobedience of the order and direction issued in the writ petition dated 2/5/2024. The writ petition was disposed of without calling for affidavits, and only direction was to the petitioner to give a representation and the district magistrate to consider the same. The order has been complied with. In fact, from the order passed by the DM district magistrate dated 13/8/2024, it is seen an elaborate exercise has been 13/8. From 13/8/2024, it is seen an elaborate exercise has been done by the district magistrate, and final order has been passed on 28/11/2024. The applicant has also been represented by the advocate. The direction has been issued to the subdivisional officer by the assistant director and block land and land reforms officer on 21/5/2025. And the subdivisional officer has also submitted a report that order has been complied with. Placing all these on record, the contempt petition stands disposed of. Next.
Now, both the reports be retained with the record.
Yes, reports retained on record. Next. Next.
Item number 22. Well, I am taking on behalf of the petitioner. All during the pendency of the contempt petition, all contempt, alleged contempt of one retired. So can you leave me granted, my lord, to inquire the name of the present incumbent? My order has not been complied.
Leave granted to the
And have the copy upon all the alleged contempt.
applicant, learned advocate for the applicant to comment the cause title by mentioning the correct name of the present officer and also serve notice on the new incumbent.
Contempt one only.
Item number 23. This first time appearing, my lord, there is a direction to inquire and file a report, my lord, but
Not complete.
not complete.
First time.
First time.
No, serve notice. Next.
Item number 24.
Please show the file. This Vinay Chara.
My lord, 20. I'm extremely sorry, I missed the item number. My lord, 24 is my application. My lord, very unfortunate incident. One senior member of the bar, my lord, has been issued with a 160 notice, pursuant to which, my lord, a warrant has been issued by the learned SCJM Bidhannagar, and also a search warrant has been issued.
In which matter?
My lord, 24.
24 is
Rajat Sinha. This is another contemner, my lord.
Rajat Sinha Roy.
Rajat Sinha Roy.
And earlier we have quashed such a notice, no?
Yes. After my lord's order was passed, my lord's order was passed on 14/6/2023. Thereafter, my lord, my 160 notice is in page number 224.
Where is the contempt here? You are not a party to that order. You file a writ petition, it will be quashed.
My lord, general order was passed that such notices are.
Sir, you can't extend it. This contempt application has been filed saying that a member of the bar has been issued with a notice by the department. Consequently, a warrant has also been issued by the additional chief judicial magistrate. The applicant would contend that the action of the authorities is in violation of the order passed by this court in MAT 1054 of 2023 dated 14/6/2023. The said order was passed in an appeal filed by another member of the bar. Therefore, we dispose of this contempt application, giving liberty to the applicant to file a separate writ petition challenging the action initiated by the authorities and the consequential action by the court of the additional chief judicial magistrate. And in the said writ petition, all grounds can be canvassed, including the judgment in MAT number 1054 of 2023 be placed before the Honorable Court for consideration.
My lord, may this application be treated as a writ petition. Otherwise, what happens? My lord, once this application is disposed, they immediately will arrest me.
Next.
Item number 25.
25, I'm for the proposed contempt, my lord. We have complied long back.
I'm for the petition number. But a payment has been made, my lord.
Long back.
It is submitted on either side.
is the
The
written
order and direction has been complied with. And the report in this regard is taken on record. This contempt petition accordingly stands disposed of. Next.
Deep level.
Item number 26.
Well, I'm for the applicant. The first time the second contempt application. First contempt application was.
Please serve notice.
Yes, I deeply obliged. Matter will appear to.
After 2 weeks.
2 weeks. I deeply.
Item number 27.
Lord, my application, first time, Lord, a brickfield, your lordship, stopped operation. It is being operated regularly. Only one order may I seek, my lord, may direct the police to implement your lordship's
Serve
order.
notice on respondent as well as the learned advocate who appeared in the writ petition. Next.
As your lordship.
Item number 28.
Well, in this matter, I have the petition. Your lordship have directed my lord to inspection the port, my lord, private respondent construction the over the khal. Therefore, my lord, your lordship direction 24 my lord, 24 my lord, near a hour. They did not take any inspection.
And who appeared for the respondent?
Respondent is a district magistrate and civil person.
No, advocate.
Advocate.
Name.
Appear করেছে।
Huh?
হ্যাঁ, কে
Samra.
করেছে? এটা?
They all not appear. Only.
হ্যাঁ, কে appear করেছে? সুব্রত ঘোষ is appear for the respondent.
Supratim Dar appeared.
Yes.
You serve notice on them. The learned advocate for the applicant is directed to serve notice on Mr. Supratim Dar, who appeared for the state in the writ petition, to enable the learned advocate to get written instruction from the client, from the alleged contempt law. List after 2 weeks. That is better. Next.
Item number 29.
Yes, your lordship. For the first time, your lordship, the direction was given to the private respondent to utilize the statutory remedy if appeal is made. They have not utilized it. Despite of that, they are operating the factory. State authority is not taking any steps.
Serve notice, including the advocate who appeared for the state in that writ petition. Next.
Item number 30.
Within 6 months, the direction was there to reopen
Same
the
order.
stadium, but HMC failed.
Same order, serve notice.
Item number 30, for the
হ্যাঁ ডুমুরজলা স্টেট ডুমুরজলাটা রিওপেন করতে বলেছিল না 6 মাসের মধ্যে
বড় কপি দেবে আমরা
আমি আজকে দিয়ে দিচ্ছি
ফার্স্ট টাইম কপি মেবি সার্ভড আপন
by today I'm giving
31.
My lord, item number 31, my lord, I am for the state, my lord.
I'm for the
By lordship, by my lord, the order dated 8th February 2024, interior directed the district magistrate to see that within 4 months from that date, a crematorium in Domkal, Murshidabad, it should be completed. But in the meantime, due to some communal issue, the state has been pleased to, my lord, entirely abandon that project due to some, and they are finding another place. I have taken instruction, but they have already got another place, Sahib Rampur, which is 4 kilometers away from that place, and they are already taking steps to make the crematorium there. Actually, there was a wooden furnace in that crematorium, the earlier one. There was planning to make some electric furnace. And for that reason, my lord, that steps were being taken, but there was some communal issue. They said that local inhabitant, they had.
Oh, now a fresh order has been passed.
No, my lord, yes, but it
different
is in the process, my lord. I have got it is in the Sahib Rampur within 4 kilometers. But may I, somewhere marked, my lord, I'm very sorry.
This contempt application has been filed alleging disobedience of the order dated.
And I am extremely sorry, my lord.
In WPAP 16 of 2024, where direction, the following direction was issued. Paragraph 3. The learned government council appearing for respondent has produced written instruction given by the district magistrate Murshidabad dated 19/12/2023, from which it is seen that the district administration has identified Shahe
Yes, the violet highlight.
Rampur
Sahib Rampur
at Chopara Gram Panchayat as an appropriate location, and the said location is less than 4.5 kilometers away from the present site. The district administration will provide all necessary support to EPIL and NMCG for execution of the same, and this will be much more viable project. Further, the instruction states that EPIL has executed some work at the earlier selected site out of the sanctioned project costs, and site being functional crematorium site next to the river requires a renovation including construction of retaining wall, and EPIL can be compensated for the work already executed by them and for the retaining wall out of the available Namai Ganj fund with SPMG. In the light of the above, the contempt application stands disposed of, placing on record the said instruction given by the district magistrate Murshidabad. In the light of the communication sent by the district magistrate Murshidabad to the principal secretary, Government of West Bengal, Department of Urban Development and Municipal Affairs, dated 19/12/2020. But this was in 2023.
Yes, my lord.
And when you will implement it?
Well, this one is, but it is now in the process of implementation, where the land to be acquired and all other process. That's why I have asked for a written report to be given.
It is submitted that the order which was passed in 2023 is in the advanced stage of being implemented. Let an affidavit be filed by the appropriate authority, clearly setting out as to what steps have been taken. 2 weeks.
May I pray one?
Not disposed of.
Not this. Well, may I pray one thing? Instead of 2 weeks, may it be 3 weeks?
3 weeks.
3 weeks.
For the communal disturbance, my lord, it is directed to be shipped another places.
It is 4 kilometers away.
All right, all right.
And without it land, nothing.
You go to an hospital by an ambulance 10 to 12 kilometers of your choice.
And not my choice.
Next.
Item number 32.
Madam, for the petition. Order dated 20th/11/2024 as directed by your lordship has not been complied with.
First
that
time?
order your first time.
Serve notice. You can serve the advocate also.
Madam, deeply obliged.
Next.
Item number 33.
33. Serve notice.
Item number 34.
34, my lord, my contempt application. And this is first time appearing before your lordship.
Serve notice, including to advocate. Next.
Grateful man.
Item number 35.
For the petitioner, my lord. My lord, it is coming for the first time, my lord.
You please serve notice.
Yes, my lord. To the advocate also, my lord.
Yes, that will make it easier.
Yes.
Item number 36.
36, my lord, I am appearing on behalf of the petitioner. First time, but I have served copies in advance, my lord.
Oh, very good.
My lord,
He is appearing very well.
report has already come.
What is the direction? What is the report?
My lord, may I show your lordships, my lord, that where the violation has happened. It was an order dated 20th of June 2024, appearing at page 21 of the writ petition. Now, my lord, the specific order is available at page 23, paragraph numbers 11 and 12. Now, my lord, only a part compliance was done. Now, my lord, the private respondents thereafter had come up in a review application before your lordships. Now, the review application stood dismissed. Now, my lord, since a substantial only a part compliance was done, now, my lord, we are aggrieved by the part that the demolition has happened. But there was also, my lord, another part of the order which stated that there has to be the restoration of the pond, which has not been done. Now, my lord, we are aggrieved by that part, that although the demolition done, restoration of the pond yet to be done, as it was there. And my lord, paragraph number 12, appearing at page 23, it has also not been invoked. Now, my lord, I have served upon all, including the private respondents as well as there. Now, my lord, even after this, my lord, a separate representation was once again.
No, now the learned friend has given written instruction.
Sir, I immediately I see, sir.
You please give copy. You go through and come.
But can you see the review order? At that time, private is a final application for review. But can you see the page? The value is a copy. Page 30. Page 30. Only the second paragraph. The official response submitted that the order has been complied with.
Yes.
Which is accepted by the learned advocate for the respondent request.
Yes, that is true. That I have stated. But that was only a.
That's correct, sir. Now they have taken action.
But it has been, the restoration has not yet been done. Of
When you will restore?
It has been done by the Katwa municipality. The
that has
state
been done
authority has had no obligation because, my lord, if your lordship kindly come to, my lord, they are the, my lord, if your lordship kindly come to, my lord, the annexure 5 of that report.
Yes, yes. But that has been just now.
My lord, they are the authorities under section 17(2) of this, my lord, the
So
regarding the.
this authority was not a party in the requisition.
Yes. It
Yes,
was there.
my lord, the Katwa municipality
No
will,
direction
municipal
was-
commissioner or the,
My lord.
they will do it.
My lord.
We have done our part.
See, so far as the state is concerned, they have
My
complied.
lord, the municipality was there. The municipality, a specific direction was there upon the municipality to take action therein.
In which paragraph there is a
My lord,
direction?
that is there.
There is no direction to the municipality.
No, my lord, the specific act, the Inland Fisheries Act and
Right. In this contempt, have you implemented the municipality?
yes, everybody is there, my lord. Who
Executive officer
And who is appearing for the municipality?
I appeal
is
for it.
appearing, my lord?
And what is your instruction?
But my instruction that has already completed, but that's not that copies they send the report. The deputy secretary also sent a notice to give the action report. That action report my client has submitted on 8 July 2000, just this year.
You please read.
Yes, just a minute. Just a minute.
Sir, you shift like little bit.
Yes,
Use the mic. Read, please.
Yes. Joint inquiry report with the undersigned caused that inquiry to the above plot and finding are as follows. The order of the Honorable High Court, such and such, the Katwa municipality as well as the office of the Assistant Director of Fisheries Department and all other officers shall demolish the boundary wall as well as the pillar, the boundary and remove the unauthorized such and such. In compliance with the above, solemn order of the Honorable High Court, the report has been sent to the learned advocate, government representative. In compliance with the solemn order, High Court, the report has been sent to the learned advocate, representing the government representative, can such and such. There has been only part compliance with the order restored upon is done. The said plot is classified as pond. Topographically, it does not mean that the entire 0.40 acre is a water body. It has its embankment, whose area is not specified in the plot information in LR map. However, it is clearly mentioned in RS map on the basis of the report of local commission of the court for the Learned Civil Judice Division Passport Katwa, titled suit number 253 of 2024, the additional director of surveys and officio, joint secretary, directorate of land record and survey West Bengal, passed the necessary rectification order of the existing LR map by this letter number such and such.
Then you do one thing. You place the copy.
My lord,
Yes,
my lord, that was also annexed with my report. Your lordship can come to annexure 2.
Okay.
So let him go through the.
My specific plea before your lordship is this: your lordship's order was very clear. There were two parts of the order. One was the demolition part, and other was the restoration part. Now, my lord, while the second kindly, while the review application was being dismissed, the demolition took place, but the restoration was a subsequent one, which was not yet done. That is why, my lord, we have come up that there is a violation of your lordship's order, paragraph 12 and 13. Now, my lord, the respondents
who filed the title suit?
Yes. My lord, that I do not know, my lord. Perhaps by the private respondents.
Between the
we can't stretch the contempt beyond this. Now we'll place these two reports on this report on record and give you liberty to proceed further. They have said that in the LR map, the embankment has not been specified. There is a suit and which says that based on the report, etc.,
Yes.
it may therefore be safely deducted that there is no separate dog number for the Pukur Park, relevant sketch map, copy of so and so attached. There is no concrete structure within 0.40 acre has been found inside the pond during this.
May I submit one thing, my lord? Perhaps there might be a private dispute going on between the private respondent and the other parties
But
regarding.
suppose your client was a party to that, we have to dismiss with cost.
Party. If he was a party at all. My lord, but it's only one thing, my lord. My lord, let the state at least the undisputed portion of the pond. Now, my lord, whoever it might be, my lord, the civil suit, that will simply determine that whose portion is belonging to the pond. But the restoration part, now that has to be done.
All right. This contempt application has been filed alleging willful or disobedience of the order and direction issued and dated so also. The operative portion of the order reads as follows. Page 23 of the contempt application, paragraph 10, 11, 12, 13.
Oh, it is the one.
The learned government counsel appearing for the report respondents filed a written instruction given by the Assistant Director of Fisheries Puru Pradama dated 3/7/22.
Local Advocate Commissioner
In the annexures, the joint inquiry report has been filed. Joint inquiry report, copy of the joint inquiry report has been annexed. The allegation of the applicant is that there has been only part compliance of the order and the restoration of the pond is yet to be done. The joint compliance report reflects the following. Page annexure 2. From the above, it is seen that there is a title suit pending. It is not clear as to who are the parties to the suit. In any event, unless and until this report is challenged by the applicant by way of the appropriate proceedings before the appropriate forum, this court cannot stretch the directions issued in the writ petition any further. In this contempt application. Accordingly, the contempt application is disposed of, leaving it open to the applicant if he still has any grievance to agitate the same before the appropriate forum in accordance with that.
Lordship, I will please to dispose of the matter, my lord, by giving
liberty has been granted.
Liberty to prefer a separate writ application. I'm so grateful, my lord. Lordship, may kindly take the affidavit.
Affidavit on record. I say affidavit of service taken on record. Next.
Grateful,
Your
my
Lordship,
lord.
I am for the petitioner. This is coming for the first time. This matter is relating to Bhu Kailash Temple, Your Lordship. On
Where is Mr. Galib?
But I have also submitted the report, to copy of the report, madam.
The contender over here is the Director General of KMC, Your Lordship, building, because they were instructed.
But what happened? Nothing has happened.
Nothing. Still constructions are going on, broad daylight. For some time it stopped after Your Lordship passed an order. But after that, no demolitions have been done. To get this.
Whether the taxis have been removed from there?
Your Lordship, taxis, I do not know of the.
I told you, no, there is one advocate, one girl, she is practicing in Alipur. Her father is sort of a caretaker of both the Bhu Kailash Mandir.
She has separately filed a writ application. This petitioner has also approached her, and before Honorable Justice Amrita Sinha, another matter is going on with the related. A single bench had passed an order. In that also they have filed.
What we can do is, we will give you liberty to intervene. Already you have filed separate writ.
Your Lordship, let it be over Your Lordships only.
No,
Because
I'm not going to be here now. What we can give one liberty, see, contempt application is not, what we can do is, if we grant you liberty to intervene in the other pending writ petition and place the direction.
all those writ petitions have been disposed of, Your Lordship.
All right, let notice be served on the respondents as well as the learned advocates who appeared for the respondent in the writ petition.
The Advocate General was appearing for the.
Let a copy also be furnished to Mr. S. Sheikh Mohammed Galib, Learned senior counsel for the state.
As a special officer, he was
It's a
appointed.
special officer. And you will take notice for the state. What is we'll engage you? You are Manisha Nath. No. Oh yes. So you appear for the state. We will issue direction. The learned advocate for the applicant is directed to serve papers on Ms. Sujata Mukherjee, along with Sujata Mukherjee, who shall appear for the state, and her appearance be regularized and her fee bills be honored. The learned advocate shall appear with Mr. Mohammed Ghalib. Full stop. The learned advocate for the applicant shall also serve notice on the learned counsel who appeared for KMC in the writ petition. Who's respondent number 11 in the writ petition?
Your Lordship.
Who? Where is the writ petition cost title?
Your Lordship, the writ petition cost title. DG building was respondent 6, Your Lordship. Respondent 11 was Akhilesh Singh, the private respondent. DG building department was directed, Your Lordship. That is respondent
Private
6.
respondent is not a party in
Your
the
Lordship,
contempt.
para 9 of the order of 30th January was the.
All right. Initially you serve them, let us see. 2 weeks.
Obliged, Your Lordship.
Next.
Your Lordship, I am appealing for the
39.
I am appealing for the petitioner. This is a first time application, contempt application.
What is the contempt?
The contempt is the that
initially the writ petition was disposed of by your lordship. This is a public interest litigation, page 25. 14.
Oh, this is a contempt of a contempt.
Despite lordship's specific direction in the contempt petition, they have not been complied till date.
Let notice be served on the respondent and also copy be served on the learned advocates who appeared for the state in CPAN 1663 of 2023, namely Mr. Tanay Chakraborty and Mr. Saptak Sanyal. List after 2 weeks.
Well,
yes, you wanted mentions of.
No, well, I just stated that in my matter, I have stated that only part compliance has been.
That we are recording. In fact, in the written instruction also, they have quoted your sentence.
I'm so grateful, my lord. Obliged.
You should not disturb lordship any further. This board is very heavy. Oh, push it. That's the
Justice Bhattacharya, because this is one contempt petition I have filed. This is the violation of your lordship's order. Lordships and sitting with my lord Justice Bibhas Patanayak, my lord. If lordship has arranged this bench.
You give the number, let
yes,
us see.
Yes, yes, deeply.
One matter is there. That madam. One West Bengal Transport Corporation. That is